May I please look? I'd like to mention this item, my lord, earlier fixed for admission. My humble prayer to Lord is, can it be on 1st of September for admission hearing, my lord? Hello. May I please? My lord, I beg to mention, my lord, PS to be taken up at 2 p.m., my lord. Here, what happened, my lord? Today, my lord, motion matter, my lord. I have filing it. Already it is filed today. My lord, here, my lord, NEET exam, after NEET exam, my lord, I participated in the counseling, my lord. I was initially allotted seat, my lord. Subsequently, it was denied, my admission was denied. Therefore, some urgency is there. MBBS admission. Tomorrow.
May I please,
I am obliged.
my lord, I have prepared for listing of a case, my lord. This was supposed to be listed on last Friday, my lord, but not listed, my lord. Lordship will be pleased to, my lord, list this case by day after tomorrow, my lord, on Thursday, my lord, 28 in admission. My lord. Thursday. Deputy Lord.
May I please, your lordship? I beg to mention item number 36, e-supply. Kindly, the matter may be adjourned for today.
Item 36.
36, 37, 37. And in this matter, in causally the part heard has been written, which is this is the matter is still not heard by your lordship. Wrongly written as the part heard.
I am for the appellant, lordship.
Only the matter may be leased after 2 weeks.
Pardon?
Only the matter may be leased after 2 weeks.
After Puja vacation, lordship.
The vacation it is too long, your honor. If it is possible after 2 weeks, your honor.
That's agreed by Lord that both the part after. You are for
I am for the I am for the respondent.
content. You are for the appellant.
Appellant.
Ah.
Obliged, lordship.
Obliged.
May it please, your lordship. Lordship, I beg to mention for listing one admission matter. May I be on Friday, my lord?
For all the
Urgently. First of, my lord. Because the petitioner, child of the petitioners are depriving from right to education, my lord. School is not there, school is shifted somewhere else. Some fundamental right to.
Lordship, with the consent of the other side, lordship, I have to mention item number 16. 16, lordship. Second consent of the petitioner, lordship. Matter may kindly be taken up after 10 days, lord.
It's a two-wheeler, but at product response. Hierarchy part. Third side. Best for the matter on.
After 10 days.
Yes, madam.
My lord,
Obliged.
this matter may come for motion, my lord, on 29th.
When?
On 29th, my lord, of this month. For motion, only one.
My lord, I beg to mention for listing of a contempt matter, my lord. It was last listed on
Think of a concept.
contempt matter, my lord.
My lord, acting for listing, my lord, one pension matter, my lord, and one another matter, my lord, 1st September.
Wait, please, lordship. I am praying for listing for withdrawal, lordship, on tomorrow or day after tomorrow, lordship. Withdrawal.
May I present, lordship? Lordship, I pray for listing of a writ petition. The matter was last listed on 4/10/2024, a year back. Thereafter for admission, lordship. Thereafter till date it has not been listed. Lordship,
Where do you
I pray for listing of it, lordship. Listing.
Where?
Lordship, any convenient date next week? Lordship, I have a similar prayer for a contempt matter, any convenient date. Obliged, lordship.
May I please, your lordship, I beg to mention listing of a written petition. The date of last posting is on 26/5/2025.
Now, where do you want?
Anytime, any date. Huh? Admission. This earlier.
May I please, your lordship, I beg to mention for listing to contempt matter, lordship.
When?
3rd September, lordship. Deeply obliged.
May it please your lordship. Lordship, with the consent of the petitioner, I beg to mention item 33, lordship. Can this matter be taken on fourth?
Next week, my lord.
Fourth, lordship.
4th of September,
Yes, lordship.
33.
33.
As agreed by learned advocates of both the parties, this is the matter on 4th of September.
Highly obliged.
Highly obliged.
Well, I beg to mention item number 26, madam.
Yes.
The matter is before the mediator, my lord. There has been positive response from both the parties. So the next date fixed is on 10th of September. My lord may take it in the month of October. There is likelihood that the matter would be settled, my lord, before the mediator.
I'm for the respondent, lordship.
Any objection?
No, lordship.
As agreed by learned advocates of both the parties, this is the matter on
October, September.
Much
Much
obliged.
May I please, Lordship, I beg. Lordship, I beg to mention item 28 to 31 of today's list.
May I pray for my lord listing the case and for the petitioner on
20 and 21.
28 to 31, Lordship.
Yes.
Lordship, here the decision has been taken, Lordship, and most probably it has gone in the favor of the petitioner only, Lordship. Here, but since there was the vacation, Lordship, the decision I could not place today. Lordship, I am seeking a short accommodation for today only so that I can bring on the record.
on 2nd of September it may come, madam.
Second.
Second of-
Okay. As agreed by learned advocates of the parties, this is item number 28 on Friday.
Yes, it can be disposed of. It can be disposed of only on.
Yes, Lordship, I think it has
Small-
gone.
Friday.
Right, Lordship.
May I please, your lordship. Lordship, for listing one rate on admission column. Any date next?
When do we want?
Any date next week.
Second.
Much.
May please, your lordship. Lordship, this matter may kindly be taken up after some time, lordship. Mr. P.P. Datta is coming, lordship.
Mr.
P.P. Datta, standing counsel APSC, lordship.
But for
My lord.
Much obliged.
Oh, my lord. My lord, in this case, my lord, the party has already got the relief, my lord.
Matter has become infructuous.
Infrastructure, my lord.
heard Mr.
FL Oscom.
FU.
FL Oscom.
FL also. He does learn understanding of the second part. The Oxford Learned Council for the petitioner made a statement for that this matter become practical as the order has already been applied. Which order they did?
This is not order, my lord. There is an interim order, my lord. There is an interim order. Subsequently, it has been, department has.
Interim order
Challenge
dated
কোনটু করেছে so complied কোনটু হচ্ছে
Not complaint, not for the contempt.
ও contempt মামলা
It is not contempt petition, my lord.
this week petition
Read.
relief has got no
Really.
acceptance.
in view of
There is an
statement-
amount, your lordship, for provisional pension of the petitioner. Your lordship, amount is 8,200 and provisional DCRG amount, which relates to 5,64,003 rupees in favor of the petitioner via his office order dated 31/7/2015. And there, your lordship, one director of pension Assam, while its order dated 18/4/2017 reduced and refixed.
made a statement before the court that the grievance of the petitioner has already been raised by the court and as such-
Recovery of excess amount, your lordship.
as such, and according to
That has recovered, your lordship.
Okay, we have closed the matter.
Yes, sir. Deeply obliged.
Obliged.
Wait for the petitioner on call, please submit your after.
May I plead the may I plead the lordship? My client has received the pension amount, so the matter is being
Infrastructures.
Hard miss,
M. Khatunia.
Patonia, guarded for the hard miss. He does turn it. Secondly, to part. Made a statement before this court. The demand already addressed by the respondent for accordingly, to the submission of hard and copy for both the parties from the
Deeply obliged.
Nice.
Lordship, Lordship, I was in item number 3, Lordship.
Yeah,
For mediation, right?
yeah. Yes, can it be referred to the mediation?
Yes, my lord. One chance may be taken. Here in this case, my lord, background of this case is that, my lord, due to wrong fixation of his scale, my lord, some, my lord, extra, my lord, salary drawn, my lord. This honorable court, my lord, directed not to recover, my lord. Even then, they did not, my lord, comply with the order.
Yes, who is appearing for elementary education? Can we refer the matter for mediation?
Yes, my lord.
Or Mr. Borgonia, guarded counsel for the petition. Okay, your good name, please.
Kedas. Kedas.
Ada.
K.
K. K. Guarded counsel for respondent in elementary education department. This matter is listed under the column number 2. It is submitted at the bar that the matter may be referred to the mediation. Accordingly, take note of the submission of the guarded counsel for both the parties. The matter is not referred to the mediation. This is a list of matter before the mediator Guwahati High Court Petition Center on both the parties are directed to appear before the mediator High Court Petition Center on 8th of September.
Well, it would be too early, my lord, because he would come from Hailakandi, my lord. Yes, 1 month, after 1 month. After 1 month.
Okay.
Diploma.
Guwahati High Court Petition. Submit the report within the stipulated period.
Obliged.
Yes, my lord, petitioner is, my lord, suffering, my lord, on bedridden condition. He is a cancer patient. It is difficult to, my lord, appear before the mediation center.
Can be referred.
No, my lord.
No.
No, my lord. But he is a cancer
What is,
patient.
what is your pair in this petition?
Pension, my lord, regarding pension,
Pension. Not payment of pension.
my lord.
Whether affidavit is filed by the respondent authority.
No affidavit has been filed, my lord, till that, my lord.
Yes, madam, are you willing to file affidavit there?
Lordship, but this matter regarding compassionate family pension, Lordship, it can be for exchange of documents and for finalization. The matter can be referred to mediation, Lordship, at least.
But he submits that,
He's a cancer patient, my lord. He's now bedridden condition, my lord.
He's a cancer patient, Lordship, but the document, if the officers come and because we don't know what is family pension, whether the documents have been sanctioned, Lordship, whether the process has been initiated, Lordship. So if the officers come in person and can give an explanation, Lordship, matters to mediation. That is my full submission. Lordship.
the petitioner is not willing to go there, then cannot force it.
Lordship.
But where is your affidavit?
Lordship, no affidavit has been.
Lordship, here education. Lordship,
We file our
When?
3 weeks.
Many occasions, my lord, they have taken time, my lord. 22 methods.
Further care pathway, learned it does. If depart that Mr. Sophia for respondent number 6, Treasury Officer.
Lordship.
So the matter is listed under the column number. The party learned for the petitioner. The petitioner is suffering from cancer and no purpose will be served by referring the matter to the media. And accordingly, response the matter for admission. There is accordingly allowed resident in the matter on overfixed in September. In the meantime, Ms. Ada Sukarna nothing talking for the respondent. May file the affidavit of this accordingly.
Oblige.
May I present, Lordship?
Yes.
Lordship, the matter pertains to Lordship, the petitioner was serving as a teacher in Lido Bazar High School. Now, Lordship, in 2016, she submitted her application for VRS, voluntary retirement from service. Now, thereafter, there was no correspondence from the authorities. Thereafter, in 2023, the impugned communication has been issued, wherein departmental proceedings sought to be initiated for absence of 5 years. Now, Lordship, your Lordship knows the law is well settled. If VRS within 3 months there is no correspondence, they do not deny that VRS application, it is deemed that it has been accepted. Under that circumstance, on the last occasion, the Honorable Court was pleased to ask the authorities whether that VRS application was received or not. That is the fact situation in the present case, Lordship. The impugned letter is at page 46.
Mediation lo কোথায় রাখা তো? Disclose क्यों करा पर मैं instruction no होते कोई को नहीं रोल.
Lordship, on the last occasion,
Lordship, I'm not able to download, re-download it, your lordship. So kindly matter may fix it to your lordship. Or after some time, your lordship.
after something. Oblige.
When in this item 7, my lord, petitioner was a retired principal of a college, my lord. He was retired on 31/5/17. Here, my lord, as he did not deposited the, my lord, open the GPF account, etc., my lord, because of the not properly fixed the pay scale, my lord. Because he was initially worked there in the Shillong, my lord. Subsequently, he has come to, my lord, Gwalpara district. After his selection, he my lord, became the principal of a college, my lord. And subsequently, he retired from service, my lord, on, my lord, 31/5/17. But all papers have been deposited by the petitioner before the authority, my lord. But they have misplaced somewhere, And they are saying, my lord, that as you have not opened the GPF account, etc., your pension cannot be given. But that letter has been challenged, my lord, page 80, my lord. So, my matter has to come, my lord. It will not.
You have filed your affidavit?
No, Lordship.
Not filed till date. It was filed in the year
To receive it, sir.
2024, my lord. It will not come, it will not be for in mediation, my lord. Matter has to, my lord, settle before the court, my lord. Before the court, because, my lord, it is not,
No chance,
no chance, my lord.
Okay.
No chance, because, my lord, there is a issue is, my lord, letter has been challenged. So matter may come on, my lord, 22, my lord.
Takes the current. You
1, 2, and 3.
So the matter is listed under the column number 22. Under the current maybe statement for that there does also pointed out that is that the content not by there according to the party the party right that is the matter of
8, man.
8. In the meantime, Mr. Upamya, Colonel Counsel for the respondent in higher education department may file the
Highly obliged.
This matter may be referred to the mediation law.
maybe.
Yes.
Part third,
D there, Rashid.
Colonel either
Matter pertaining to new pension and old pension, your lordship.
No, it is
So
not a matter.
it is not the matter for mediation, your lordship. So we are objecting, your lordship. Kindly, it is not sent to the mediation.
secondary education part. And you are appearing
For elementary education.
yeah, for the thing of the online part. Thus, Colonel sending for the respondent in secondary education department submits that the matter relates to granting of pension under the
Old
or new
pension scheme. Yes, your lordship.
New-
Old pension scheme and new pension scheme, your lordship.
as the no purpose or if the matter is referred to the committee. According to the party that basis of the method. Oh, you have filed your affidavit?
We will be filing our affidavit, your lordship. Kindly 4 weeks time may be granted to us.
In the meantime, the respondent authorities may file their affidavit.
I'm deeply obliged.
Your lordship, kindly pass over the matter for the time being, your lordship.
My lord, it have already come, lordship. I am for respondent number 9, lord.
Yes.
Okay, subject to is. My lord, I'm available, lordship. Your lordship may hear the matter. Lordship, matter relating to lordship, family pension lordship. Lordship, the petitioner herein is the divorcee lordship. She was way back in the year 2007. She was divorced by the husband of the present respondent number 9 lordship, and left her to his lordship paternal residence, giving her all the lordship properties to her. And thereafter, in the year 2007 lordship, he married me lordship, the respondent number 9 here in lordship. And thereafter lordship, 3 child was born, 2 are minor, 3 are minor lordship, and 2 are mentally disabled lordship. And now lordship, after death of the husband lordship, she claiming the family pension. That is the entire facts lordship. The only one thing is that lordship, there is a judgment passed by the
Here
learned.
is the matter today. You tell me whether any purpose will be served if we refer the matter to the mediation.
Lordship, if it will be referred, Lordship, then nothing will be, no purpose will be served, because Lordship, her claim is totally
Or Mr. R. Colonel.
NH Borbuyal.
NH or Colonel. Or 9.
Respondent 9.
And you,
For respondent number 6, sir.
your name, please. Your name,
A. Sanyal. I'm for KK Nandi, sir.
okay?
KK Nandi.
For respondent number 6 and 7. Then elementary education.
Yes, ma'am.
Or submitted with the card. Who the matter is the submitted at the card and purpose of card. Matter is referred. Provided that the list of the poet. After vacation or before vacation.
Then you may kindly fix, Lordship, because there is an interim order also.
But in the meantime, the responsibilities may file their affidavit in Ogun.
My lord, only one thing, Lordship, due to stay of this Lordship, entire pension, Lordship, because at least, Lordship, the minor
File your
child have a
affidavit.
right, Lord.
You file your affidavit.
I have already filed, Lord.
Order consultation.
Online.
That is a lot. It relates to non-payment of family pension. Not. They are yet to find their affidavit. But
Can it be referred to the
no, no. Mediation will not serve the purpose.
or sir, order the positive for respondent number
5.
Number 5. Respondent number 5 is the district elementary
Education.
and for rest of the respondent.
P4 standing council Limahasa will.
Well, I will inform them.
Do the matter is listed under the call.
Local education.
Number that purpose is served by. Accordingly, it is provided that the on okay. In the meantime, the respondent authorities may file their affidavit in
Okay, sir.
Lord, the matter pertains to payment of pensionary benefits to the petitioner due to the death of her husband who was serving as in the Cotton College, my lord. So probably the matter may be sent for mediation. Let them come and whatever the authorities pay, my lord.
Yeah.
Yes, sir. We have no objection.
part submit for us.
H. Chetty Lordship, on behalf of Mr. P.D. Nair, for P.D. Nair Lordship, is standing as a Cotton University. Respondent Lordship, 4. No, 2,
4, 5, 6.
4, 5,
4, 5.
4, 5, and 6.
4, 5, and 6. And you?
K. Boro on behalf of Mr. C. Boro for respondent number 7.
K. Boro,
Accountant General.
Number 7.
Accountant General.
Informative for
1 and 2.
respondent number 1 and 2. And Mr.
Number 3.
Begu for respondent number 3. So we are referring the matter to the matter.
Yes, ma'am.
The Bora learned for the that the matter is referred to the matter. Accordingly, taking the sum of learned for the and also the are directed to appear before the 98 or Guwahati High Court at the mock
Any date, your lord.
the package of some article for
Obliged, my lord.
May it please your lordship. My lord, the matters pertaining to rights of persons with disabilities act. My lord, here, my lord, the petitioner challenge one advertisement advertised by the APSC, my lord, which is annexed 10 to the writ petition, my lord. No posts were reserved for physically disabled persons. And my lord, the petitioner has furnished the advertisement from the year 2017 to till date. There are 34 posts were advertised. Out of 34, not a single post has been allotted to the persons with physical disability. And my lord, here, my lord, they have on several occasions they filed one, they produced one after another communication, my lord. They were asked to furnish the instruction, my lord. Till date, my lord, no affidavit has been filed, my lord. And instruction. What is your instruction? No, instruction to please.
The lordship, the petitioner's grievance is that the post to be reserved for PWD candidate has not been earmarked in this advertisement. Thereafter, after this filing this petition, there was a deliberation of communication between APSC and the concerned department, and concerned department has clarified the APSC that total cadre strength of that cadre lordship is 41. And as per section 34 of the PWBD Act, 4% of the total cadre strength to be earmarked for the benchmark disability. And on that basis of that provision lordship, one push ought to be reserved against total cadre strength of 41, and that push has been benchmarked for deaf and hard of hearing. And APSC, in pursuance of that clarification, APSC has already issued the addendum lordship. And the petitioner's before lordship is belongs to the locomotor disability. So he has no claim over the benchmark reserve, post reserve for the benchmark disability.
My
He
lord,
can participate in other open category lordship.
my lord, let them file the affidavit. Place this instruction as an affidavit, my lord. And let me take instruction, my lord.
you furnish the copy.
Yes. This is already website published in website.
Let me take instruction on that, my lord. And my lord, till date we don't know what is the cadre strength.
The 41.
My lord, where from? Where from? Where from they are saying, man?
Lordship can record my submission.
My lord, how it can be, my lord? Let them file affidavit.
No.
On cadre strength, my lord. A cadre strength of inspector of schools, such an important office, my lord. Till date, we are in 2025. Till date, no reservation has been given to the physically disabled person. How, my lord? Why, my lord? These questions are staring at us. Why? Why we have to approach this honorable court for this, my lord? Throughout the country, they are giving reservation to physically disabled person. Why the state of Assam, that too an important department like education, they are not following? No. Let them file affidavit.
You file to
Lordship, education department is represented by my learned friend. I am for APSC lordship. I can also file lordship, no issue.
We, on the earlier, your lordship, dated your lordship, we also placed our instruction, your lordship, that one person it shall be reserved for person with benchmark disabilities under clauses A, B, and C. That your lordship already submitted, your lordship.
Let them file, my lord. How they kindly pay section 33, my lord. Section 33 is saying, my lord, we 1% of each of the category. That is section 32.
how they selected different hard hearing person only to deprive the petitioner, my lord. Can you page section 33 at page 19?
Yes.
Identification of posts for reservation. The appropriate government shall identify posts in the established.
Referring to Act of 1995.
No, my lord, 2016, my lord. Oh, oh. এখন দিতো। Kindly pages 33 and 34, my lord.
4%.
4% of total cadre strength, and section 34 reads every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadre strength in each of group of posts meant to be filled with persons with benchmark disabilities, of which 1% each shall be reserved for persons with benchmark disabilities under clause A, B, and C, and 1% for persons with benchmark disabilities under clause D and E. Namely, A is for blindness and low vision, B is deaf and hard hearing, C is locomotory disability. My lord, the petitioner falls under category C. And my lord, let them justify how they selected different hard hearing. Why not? Because it is given 1% each, and for that result, as per my understanding, that they have to call all the PWD, and among them, then they will choose. So let the matter be fixed after 3 weeks, my lord. Let them file affidavit.
Sir, the bocho product APS and secretary report.
I'm appearing, your lordship, for respondent 1, 2, and
I am for the APS, Lord. 4 and 5.
One added approved by the APS. Dated like the
inspection of the
letting that we PWB candidate under the category art of hearing are eligible. Accordingly, it provided that the doctors filed a court affidavit bringing on record the instruction received and urgent for the court to make. The fact he does furnish sending counsel for the respondent higher department also file an affidavit. Let's take the matter after 3 weeks. Is there any interim order according?
No, Lord.
No, my lord. How less than?
Lordship, any other date except 19 September? Any other date except 20 September? Lordship.
May I please? May I please? Lordship, in this case, was earlier heard by part heard matter. Lordship, Mylar versus L. Zomi has heard the matter. Subsequently released. Earlier, this matter was heard by Mylar versus L. Zomi. Lordship, that was subsequently released. Lordship. What happened in this case, Lordship? The petitioner was appointed in the year 2000, Lordship, on 1/2/2000, Lordship, as a night supervisor. From 2000, the respondent has utilized his service by paying only 416 rupees per month. So we have Lordship filed the item number 30 for paying the minimum wages in terms with the Upenda's case rendered by this honorable division. And during the pendency of the said petition, item number 30, Lordship, without following the due process of law, only at the instruction of the director, Lordship, the petitioner was released from service. Lordship, if I place the required relevant documents, Lordship, from page 28-29, Lordship, these are the petitioner's appointment letter, engagement letter. These are the
Number
page 28. Item number 12, Lordship.
item number 12.
12. These are the engagement letter, Lordship. And page 32 is the certificate issued by the Deputy Inspector of School, Majuli. Mary.
Yes.
This is to certify that Sri Tonkeshwar Borua, son of late Madan Borua, an inhabitant of Dariagao, PO so-and-so, having class passed by the qualification, who has been serving as casual employee engaged by the then Deputy Inspector of School, Majuli, in the office of the Deputy Inspector of Schools, Majuli, Kamalabari, since 1/2/2000 and till date. He has been paid a lump sum amount of rupees as per allotment of fund received from DE Assam, Kahilipara, Guwahati. He is very obedient, sincere, regular and faithful. He always keep the office clean and nourished in the flower garden, which enrich the natural beauty of this campus. Considering the sincerity of service, he may be regularized against the post lying vacant due to expiry of Nobin Soikia, night supervisor of this school. Hereafter, Lordship, his one representation was submitted, that was, Lordship, forwarded, page 33, Lordship. Regarding the appointment of grade 4 staff in the, kindly accept our heartiest respect. With due respect, this is to inform you that we have come to know that Sri Tonkeshwar Borua, son of late Honorable resident of has been working as night supervisor on honorary basis in the office of the Sub-Inspector School Education Department situated at Komlabari. As such, it is paid to help the livelihood of that family. Appointed Sri Tonkeshwar Borua in the recent occurred vacant position of night supervisor by the regularized. So, Lordship, pursuant to the Umadevi case, Lordship, since he has rendered 10 years of service, Lordship, the respondent, the Deputy Inspector of School, has forwarded the same, page 37, Lordship, to the Director of Elementary. Forward the petition of Sri subject. Forward the petition of Sri Tonkeshwar Borua, village so and so, in connection with fixed pay work.
What about thereafter?
Yes, sir. With reference to the subject cited above, I have the honor to forward the petition of Sri Tonkeshwar Borua so and so, in encounter of fixed pay workers. Does it make page 38? Department Elementary Education, name of the incumbent Tonkeshwar Borua, date of engagement 1/2/2000, scale pay amount fixed 460 per month, 416 per month. From 2000, his service was utilized by paying 416 per month. And accordingly, his case was forwarded, but this since no action has been taken, Lordship, we have approached this honorable court by filing the item number 13. Wherein this honorable court, case 44, notice was issued.
In item number 13, notice was,
Notice.
and that notice is the page number 40.
Page 44, Lordship, we have annex Lordship. Page in item 12, we have annex that order. Lordship. If Lordship peruse the prayer of the item number 13, Lordship, we have not filed this case for regulation. Lordship. We have prayed for a direction to consider the case, Lordship, to pay, extend the benefit of fixed minimum wages of the remuneration with clearance allowance, dearness, etc. to the petitioner at the rate of existing minimum wage entitled by the regular government employees in terms with the judgment dated so and so open the case. So our case is for minimum wages because he was paying only 416 rupees. And this honorable court has issued notice in that case. Okay. And when issuing notice, Lordship, this honorable court has also observed in page 46, Lordship, pendency of this requisition shall not be a bar for the respondent authorized to provide the petitioner the amount entitled by him in terms of the decision in the case of open case. And accordingly, certified copy of the said order was submitted before the respondent by the petition. And thereafter, the said case was next listed on 23/2023, case 54, Lordship, wherein the respondent was directed to file a petition. Now, during pendency of the said petition, Lordship, page 56, last page, Lordship. Now, director came up in the picture, Lordship, and he has issued this letter, page 56.
Page
56, no, last page. Mary. With reference to the subject matter, I would like to inform you that Tonkeshwar Burua under Majuli district has filed a case before the Honorable High Court bearing WBC number 8342/2022 to extend the benefit of fixed minimum wages of the remuneration in the current post of night supervisor in the office of the DIS Majuli till his normal supervision is. In this regard, the parawise report as received from your end, white later under reference, it is shown that the petitioner was temporarily engaged on daily basis in the office of DIS Majuli from 1 to 2000. As per order of DS Majuli dated so and so. But no formal appointment letter was issued by the competent authority. The appointing authority is Director of Elementary Education, Assam. Further, there is no government provision for any such private engagement by the officer. Therefore, such engagement done by the DS Majuli is illegal and violation of provision of government guidelines. So you are hereby asked as to how a private person was engaged in your office establishment by violating the government notice issued from time to time. You are also directed to take immediate and stringent steps to release the private person from your office by issuing a speaking order. Lordship may mark this by issuing a speaking order. As per the government rules and procedure, the action taken report should reach the director on or before 18/4/2023. Positive. So this letter was issued on 5th of March 2023, Lordship, and directed to action taken report to be raised by 18/4/2012. Now the DS Majuli has done page 55. He was directed to action taken report be submitted on or before 18/4. Now he has passed this order on 18/4/2012. And the direction was to pass a speaking order. Now he has passed this order, impugn order. As per the letter received from the DE Assam White letter number says, Tonkeshwar Burua is hereby released from all the temporary engagement at the office of the Deputy Inspector School, Majuli, and this order come into force with immediate. So there is no speaking order, no opportunity was given to the petitioner, Lordship. And if the petitioners, if assuming that he was not appointed by following the due process of law, there is no the government position for any such private engagement. But what action they have taken against the state DIS? The affidavit filed by the respondent is silent about. We are paying for the from 2000, Lordship, 1 to 2000, his service was utilized by paying only 416 rupees, Lordship. That is admitted by the in the elementary director's letters also. It was parawise receipt wherein it was stated that his service was engaged from the 2000. And accordingly, the director has directed to pass a speaking order as per provision of the law, as per by following the rules of the government procedure, but no such procedure has been followed, and has simply complied with the state direction on the date, on the last date of, because it was directed to reach the state external candidate on or before 18/4, and accordingly 18/4 this order has been passed. So it is clear case, Lordship, the no opportunity was provided to the petitioner, as well as the we have filed. Our services was utilized from 2000, Lordship, by around 22 years, Lordship, by giving only 416 rupees. They have filed their affidavit, Lordship. Affidavit same ground has been taken. Lordship, Lordship knows about the Upenda's case, Lordship. Earlier, Lordship, we have provided the copy. In the court. I don't know. In terms of the paragraph 22 of the Upenda's case, Lordship, the government has also issued a circular, Lordship. That was issued on 3rd October 2019. And circular was, we have annexed as 841. Page 41 is the circular, Lordship, whereby the government has taken a conscious decision, Lordship, in terms of the Upenda's case, and accordingly fixed the wages of the remuneration of rupees 15,900 with DRNS allowance to the workers employee. So I am also paying for that. Lordship. In paragraph 6 of the dear affidavit was filed, Lordship, director has filed affidavit. Dear ground, paragraph 6. No? Paragraph 6 and 7, Lord. May I read?
Where is the document to show that you have been engaged the year 2000?
Lordship, page 38. It was forwarded along with the page 37, Lordship, forwarding letter. Date of engagement, Lordship, 4th column. And that was not disputed, Lordship, because in the communication, impugned communication also, the director has stated, Lordship, as per parawise received from the office of the Deputy Inspector of School. Second paragraph, page 56, Lordship.
Page number?
Page 56. Look. Second paragraph. In this regard, the parawise report as received from your end violated other reference. It is shown that the petition was temporarily engaged on daily basis in the office of DS Majuli from 1 to 2000 as per order of DS Majuli. This letter was page 37 also forwarded to the director. So director is aware about the fact. All the engagement letters, Lordship, if
Why similar order could not be passed, like the key of Upendas?
Well, first of all, my lord, Upendas is not applicable. My lord. Upendas was in respect of master role and work charge, my lord. Those employees, my lord. Now here, my lord, this is a case, my lord. Categorically, our stand is, my lord, that there is no engagement letter in the record of the office of the inspector. If on a personal capacity, some authority who is not competent has appointed him, my lord,
No,
that would not be.
where it is stated that in his personal
My lord,
capacity, he was appointed.
our categorical Lordship will kindly first paragraph 4, my lord, page 58.
Where is the document to show that he was engaged in part?
No, my lord, the statement, my lord, will kindly see.
No, your statement will not do unless supported by any document. Where is that document support your statement?
There cannot be any document because when we don't have the document with regard to engagement in our official record, because it is his document he has brought in by way of this repetition.
But you
My
have
lord,
not been disputing it.
no, we have disputed, my lord. Your lordship will kindly see para 4, my lord. Para 4, para 6, my lord. With regard to para 2 of the repetition, it is in respect of the, my lord, the reply to paragraph number 2. The answering reporter begs to state that the petitioner claimed that he was engaged on daily basis wages by the deputy inspector of school so and so. But the deputy inspector of school in his report dated 17/5/2024 has stated that the engagement order is not available in his office as claimed by the petitioner. Paragraph 3. Reply to paragraph 3. The answering deponent begs to state that as per report submitted by the deputy inspector of school Mazuli, the phrase engagement order issued by the division is also not available as claimed by the petitioner. Well, these are the documents which are annexed with the writ petition. That with regard to para 4 of the writ petition, it is mentioned here that a certificate was issued by the deputy inspector of school on 8/2/2013, wherein it is stated that the petitioner has been serving as a casual employee since 2000 and he has been paid a lump sum of rupees as per the allotment of fund received from the director of elementary education. But no formal appointment was issued from any competent authority. Further, the deputy inspector of school is not competent to engage any private person in office or school engagement as per government rules. There is no such government provision for direct recruitment by the deputy inspector of school. Therefore, to engage a private person in a government establishment is illegal and in violation of the government rules and procedures. Hence, the petitioner cannot claim for regularization of his service. On the other hand, the petitioner was not engaged in any sanctioned post. He was rather engaged as a wages in a.
He has not been trained for regularization.
No.
Trained for minimum. Yeah.
Yes, but for that also, my lord, there has to be a valid engagement by a competent authority.
No, where is the environment that the engagement letter by the deputy inspector of or obtained by fraudulent?
Well, paragraph
Merely
59.
because the document is not available in your office, that does not mean that the engagement letter produced by him is a false document.
But to impute a force, my lord, there has to be an inquiry first. But however, this is the letter which is produced by him. The burden is on him to prove it that it was the.
He has produced it. He has annexed it.
Yes, and
There
to that statement, my lord, there is a categorical denial that this document doesn't contain in the record, my lord.
Those documents bears the official seal and signature of.
Even, my lord, even if assuming, my lord.
You come to page number 28. The name of the person appointing, who appointed him is also there.
Yes, sir. Please get. Well, assuming, my
The
lord.
official seal is there.
Yes, yes. Assuming, my lord, there is a letter by the deputy inspector of school. But even that will not give him a benefit of claiming, because when that authority does not have a jurisdiction to authority, the power to appoint him, my lord. Because rule provides, my lord, the appointment to as a direct recruitment, my lord. He cannot, the one officer cannot take a backdoor entry to.
Initiated against him, against the deputy inspector of school who had appointed him illegally.
My lord.
Where is the inquiry report?
I'll have to take instruction on that, my lord, whether any action is taken or not. Because here the subject matter was not with regard to what action has been taken against that officer, my lord.
That's right. You have taken a categorical stand in your affidavit.
Yes, sir.
But to establish the same, to substantiate the same, what inquiry you have done?
My lord,
Is
this.
it sufficient that the document is not available in the office?
No, my lord, in reply to the categorical statement of the petitioner in the repetition, my lord, our categorical reply, your lordship will kindly see from para 4 to 8, my lord. We have disputed, denied his engagement, my lord.
You come to page number 59.
Yes,
Paragraph number 6.
my lord.
The last sentence. On the other hand, the petitioner was not engaged in any sanction code, he was rather engaged as wages in a lump sum daily basis. Is it not admission?
No, my lord, what his claim is that he has been paid from the fund that is allotted by the district director of elementary education, Assam, for running the office. That is by the deputy inspector, my lord. Lordship will kindly see para 6 to the first, my lord. In context of this, my lord. This statement is made in context of para 4 of the repetition. May I just read para 4 first? British para 4 of the repetition, my lord. The petitioner begs to state that since the petitioner was disbursed with a minimum salary of rupees 416 per month, he was requested the respondent authority to take immediate steps to regularize his service, and accordingly, the respondent authorities have also assured that his service will be regularized after completion of 10 years of service. This regularization thing has come because of these pleadings, my lord.
There is no.
No, no, that,
No,
yes. In the writ petition,
made in this petition.
in the writ petition, my lord, though the prayer is not there, but his request throughout, he has, as he is claimed in paragraph number 4, my lord, on a legitimate belief that his service will be regularized after completion of 10 years of service, he has rendered his service without any objection. However, even after 10 years of service, since no concrete steps was taken by the respondent for regularization of the service of the petitioner, he has made representation before the respondent for regularization of his service, which, however, was not taken into consideration by the respondent till date. So, my lord, in this context, this reply is being filed. Para 6, my lord, is a reply to paragraph 4 of the writ petition.
Yes.
Page 59.
You see paragraph number 22 of
Well,
the judgment in case,
well,
where not only the master rule and works as employees are mentioned, but also similarly placed employees. Whether the present petitioner is not similarly placed?
In my respectful submission, my lord, not, my lord.
Not. Any other offer, any other respondent? Nothing to. What is your pair in item number 13?
23 Lordship, impugn that order, release order, challenge Lordship.
Okay, that has been stayed by this court.
That was stayed.
No, not state Lordship, but subsequently a interim order was passed Lordship. Is on 8/2/2020, 8/12/2023 Lordship, in item number 23 Lordship, to the extent that the respondent in the eligibility.
State.
But till such affidavit is filed and the matter is taken up on the next day, the service of the petitioner be not discontinued. Lordship, he has already released. Before that order passed, Lordship, that was already.
That release order has not been challenged.
No, challenge Lordship. Is both page 56 and 55 both challenge Lordship. Prayer Lordship, page 24.
8/12/2023, there is an order not to discontinue.
Yes, Lord. But they have not allowed to continue.
Devendra, sir.
What is the release order?
Page 55 on 18/4/2020. In terms with the direction of the page 56. Lord. If Lordship peruse the requirements made in the repetition paragraph 22, 23, and 24, they have not disputed the same. Paragraph 22, we have, if Lordship may allow me to read. Regarding the what action they have not taken any action against the deputy inspector, that was also I have raised. Paragraph 22, that the petition begs to say a mere perusal of the later dated 5/3/2023 issued by the Director of Elementary Education makes it discernible that as the Deputy Inspector of School Majuli was directed to take immediate steps to release the petition by 18/4/2023, the impugn order has been issued by the Deputy Inspector of School Majuli by giving a backdated order. Further, though the Director of the Elementary Education School Assam has directed the Deputy Inspector to pass a speaking order as per the government rules, but no such procedure was followed while issuing the impugn order and thereby violated the principle of natural justice. Against the paragraph, that paragraph Lordship, they have that with regard to the statement made in paragraph 19 to 24, the answering report respectively begs to reiterate and reaffirm the statement made in paragraph 6 of the affidavit. They have only reiterated that regarding the natural justice following the, they have not replied to the same. And in paragraph 23 also, we have averred that the petitioner humbly begs to state that although the petitioner was appointed temporarily by the issuing press engagement letter by the Deputy Inspector of School Majuli, but apparently his service has been utilized by the respondent since 2000. The appointment order annexed herein above would go to show that the said appointment order was also marked to the Director of the Elementary Education Assam, and as such, the Director of Elementary Education Assam is aware about the engagement of the petition.
Well, in this manner, with regard to our stand taken, manner, I would like to rely the Honorable Apex Court judgment in Devendra Kumar Sharma versus State of Bihar, manner.
You furnish it to the court.
I'll give a copy, manner. Here, manner, this has been.
K. Kolita.
K.
K. Kolita.
K. Pardon.
Lordship, in item number 13, only in item number 13, Lordship, I am for respondent number 6.
In item number 13 for respondent number 7. Argument concluded, order is adjourned.
Hello.
May it be pleases your lordship. Here, your lordship, Deputy Director of Secondary Education has wrote down one letter, your lordship, to Inspector of School TDC Tinsukia in connection to this, your lordship, to submit a factual report regarding the authentication of the communication wide letter dated so and so in respect of petitioner application for VRS, which I would like to place it, your lordship. Last line, your lordship. As the petitioner was purpose for granting of extraordinary leave only and not for voluntary retirement as claimed by the learned counsel for the petitioner, Srimati Krishna De Bhumik in the Honorable High Court, your lordship. Further, it is to be stated here that from the writ petition and its enclosure, it appears that a communication bearing same dated, which is 31/5/2016, by letter number so and so, which is enclosed at page number 31 of writ petition, was addressed to your good office by the headmistress of Lido Bazar High School, Tinsukia, without prayer petition of the petitioner to allow her to go on VRS. Your lordship, pertaining to that, your lordship, in this connection, you are therefore requested to inquiry into the matter thoroughly and to submit a factual report regarding the authentication of the communication wide letter so and so dated 31/5/2016 in respect of the petitioner application for VRS, your lordship. So, your lordship, kindly grant us some time, your lordship, till that, your lordship, factual report is needed, your lordship.
Hard, sir. Hard.
A Chakraborty. A Chakraborty. A Chakraborty.
Yes. Learned and hard. That or better by the left for like TTC, yeah, that's like uh no, requesting to inquire into the method of
Authentication
of the communication by letter number LPHS from MIS of the 01 dated 35 of year, and that the instruction is being awaited by letter after 2 weeks.
3 weeks, your lordship.
After there is after the letter produced before the court says that the mark that A the main part of the
There is an interim order that may continue.
order on
I'm deeply
Obliged.
Lord, my senior Mr. A. Deka, my lord, had sought for timing. Done with that. A. Deka. Adjournment, timing. I do not have hold the brief, my lord. I've just been instructed by Mr. A. Deka to take some
Last
time.
occasion, I was instructed to.
He's on
Rapid
legs.
instruction. Better maybe 6 up to 3 weeks, madam.
Fine.
Just. Just. Lagi na? Very interesting, my lord. The letter issued by Director of Pension.
Last year.
Last year is received.
They have received last week.
Interest. It will take time. Get time. Idilo. Idilo. Idilo.
Mr.
But I do not, my name does not feature in the cause list on behalf of,
Maybe,
M.
before
Col-
leaving,
on behalf of ADEC, ADEC,
Mr. M. Sharma, Learned Counsel, behalf of A. Dekha, Learned Counsel. And Mr.
R.K. Musari,
R.K. Mutare,
any council BTC, any council.
for BTC. Mr. Sharma for
Respondent number 6.
respondent number, and Mr. Regu for
Respondent number 5.
respondent number 5. The Mutare, Learned Counsel for the BTC as part of the court letter 5, written by the director of the court, Boduland Director. Present the part 4. Requesting of the job in finance department of the excess drawer of pay and allowances of rupees 4,67,212 as per government. As per government. In ARP and part letter number 3, it represents 7 from 2009 from 19 respect to the present petition. And he prays for listing the matter after 3 weeks. Where is according to allow, let's submit the matter after the letter produced to the court list shall be marked next day and shall be made part of this record. This is the matter after.
Miller, we have filed an IA, Miller. I'll be led by Mr. Ken Miller. He's on leaks in another court. Maybe adjourn for the time being.
My lord, there's some development in the matter.
Miller, since Mr. Ken will lead me in this case, Miller, and there is some urgency. So, Miller, matter may come up after a little while.
After?
After a little while.
My lord, the matter is pending before the Honorable Supreme Court. Your Lordship, what has happened is, what has happened without going into the merits, the petitioner was summarily terminated. Pursuant to that, my lord.
Milord, since Milord, it is it amounts to go into the depth to the merits of the case, Milord. So, since Milord, my senior will lead me in this case, some sensitive nature of the case, Milord. So, Milord, it will be done for the time being, Milord. My learned friend will submit afterwards. Milord.
Same parties, my lord, in same capacity. AK Henry had short time to file their affidavit in that matter, my lord. If that matter is decided, this matter will be rendered infructuous. But that is my submission. Let my senior attend, my lord.
For the time being.
Please, matter में password for the time being, Lordship.
Yeah, please, my lord. My lord, in this matter, my lord, a TCR was called for, as well as, my lord, this is a popular matter. Notice was issued to the PP. So, on the last occasion, Lordship directed them to take the instruction with regard to service, and, my lord, as per office note dated 28/2025, office note dated 208/25, my lord, reminder is issued for TCR but not received, my lord.
Well, there has not been written.
Not received.
And notice also not been served.
No, my lord, the FPP is directed to take the instruction.
But for some time, I think from the FPP.
May it please, Lordship. So this second bail application, my lord, under the NDPS Act, my lord, the accused is in jail for 1 year and about 4 months. There were 5 accused, my lord. Other 3 has been released. Your lordship has released 2, and the 1 has been released by the learned session judge. The lordship's earlier order is here, my lord, at page
No,
4,
they,
my lord.
this side is absent now. Court master will inform the KPP wait for some time.
May it please the Lordship. Lordship, last occasion order dated 8th of July. May kindly be perused, Lordship.
The trauma developed.
My lord, regarding Morales sake, contempt number 532/2024.
It's contact matter.
Yes, item number 20. It is now it is in the government departments, my lord. So it is lying on DR, my lord.
Where?
Under the government, my lord, government office. To the secretary. So sometime may be required here, my lord. And regarding the, my lord, WPC 3093 of
In this department,
under government, my lord, it is. In
Lordship,
earlier
proposal
date
has
of
been sent
29/7/2025.
on 26/6/2025.
26/6. My lord,
So,
I have already submitted a letter dated 29/7/2025. It is written by Mamata Huzai. It is directed to the secretary to the government of Assam. Here it is stated, I would therefore request that government may be pleased to accord necessary sanction for an amount of rupees 6,66,400 only in respect of Omar Ali Sheikh, a assistant teacher, tutor of Balisar HS under Dhuburi district out of budget provision. Budget provision is there of rupees 1,000 lakh for the financial year 2025 and 26.
That's why that letter was written on 29/7/2025.
Yes.
So what happened in the meantime? That instruction is required.
So sometime may be granted. I will obtain the instruction.
You verbally obtain the instruction. You place it before the court at 2 p.m.
Yes.
In other items,
Lordship, in this matter, Lordship, the current salary has been received by the petitioner.
then what remains there?
Area salary, Lord.
Area salary.
Lord.
And what is the status here, Mr.
Yes, my lord.
Thomas?
Here, my lord. Proposal of area salary yet to be received from the concerned school, my lord. School of the petitioner.
Lordship, it is in the inspector of school, DDC Dhubri, Lord. They have to submit the proposal. My learned friend is also appearing for the inspector of school.
No, as per my information, it is received today, my lord, itself. So, regarding Abdul Ghafoor, as informed by the IS, he already received current salary and the area salary proposal yet to be received from the respective school of the petitioner.
Not received.
Yes.
Whether the headmaster is a party here?
Lordship, headmaster is a party.
Party. You are appearing for headmaster also?
No, my lord, I am not appearing.
Headmaster, one MZ party, one MZ is appearing, Lordship. Lordship may be taken at 2, Lordship, he will
Okay, at 2. You inform MZ.
Lordship.
And you also obtain instruction whether the headmaster has submitted the proposal or not.
Will. Public.
May I please, Lordship? In this case, after several direction, today they file affidavit. I have received copy. So, may come on next week because there is urgency. The petitioner is going to review. 2 months. In the affidavit, they have only taken a feeling matter my age. All
What is that?
okay. So in the affidavit, they have
Your name.
Due.
D Gogoi, Learning Council Product, online content number.
Sole respondent.
Mr. Gogoi submits that the respondent has filed an affidavit and he has received a copy today. And he tries for granting go through the same book and if necessary respond to the same and respond to the matter.
Possible next week. Because there is Aditya Malot, he was going to retire. Next item is also
Same mail.
same.
So the next item, my lord, may I pray for 8, my lord, because we are also filing a review today, my lord, against that order, my lord. So perhaps, my lord, that 23, my lord.
What will one?
23, my lord. Can it be on 8, my lord? Grateful, my lord.
20.
Please, Lordship. In this case, Lordship, order is started with 59. The operative part is at
Up to date inspection, Mr. Verma, you received the inspection.
My lord, here direction was there, my lord. The Secretary to the Government of Assam in the Department of School Education shall place the case of the petitioner before the next meeting of SLC for compassionate appointment afresh for her compassionate appointment, considering her eligibility in any grade 3 post, being a master degree holder in Assamese, relaxing her overage at the time of the application for compassionate appointment in terms of clause 16 of the office memorandum dated 1/6/2015 noted above as applicable. And here the secretary has placed the matter before the SLC on next SLC meeting, which was held on 18/8/2023. Here it is mentioned in the order itself also, in pursuant to Honorable High Court.
Where is that order?
It was earlier, I have already produced here, my lord, and this is the order here. Order and instruction. So here, my lord, it is stated, in pursuant to Honorable High Court's
Yes.
my lord, order is there, my lord. Before last page, second last page, my lord. And here, my lord, paragraph 3. And from bottom, it is second paragraph. In pursuant to Honorable High Court said order, the case of the petitioner was again placed in the matter in the meeting of the State Level Committee on Compassionate Ground Appointment held on 18/8/2023 for consideration. Accordingly, the SLC, after examination of all the available documents, thoroughly directed the Department of School Education to take views of the personnel department on the matter of the relaxation of her office and thereafter to place the matter again before the SLC. Kumalat Secretary has placed the matter before the SLC on 18/8/2023. This is the next meeting held after my lord order dated 28/4/2023.
Then whether an SLC was held thereafter.
SLC was viewed that matter may be placed before the personnel department, and here it is take views of the personnel department on the matter relaxation of her age and thereafter the place the matter before the SLC. And thereafter, my lord, in the next paragraph, as per recommendation of the SLC, Department of School Education took necessary steps to take a decision on the condonation on the basis of standing office memorandum of the personnel department, and also to obtain views of the personnel department so that the matter can be placed before the SLC on next meeting. But in the meantime, Personnel B Department issued an office memorandum that so and so 18/9/2020 directing all department not to entertain any cases of compassionate ground appointments, including the cases not known prior to 31/3/2017. As per this office memorandum, the cases of the employees who die or died in harness after 31/3/2017 have been taken care by way of compassionate family pension scheme in lieu of compassionate appointment. Right? Office memorandum number so and so.
You were explaining the benefit of the office memorandum.
Lordship, the one that I have to submit, Lordship. First of all, he was directed to place the case of the petition before the SLC. Next direction, Lordship, from the honorable space.
My question is whether government received the benefit of the OMC by the personal department.
I have no information, Lordship. There are specifications from the court.
No, I am asking which were receiving the compassionate family pension.
I am only getting the family pension, Lord.
Getting
Lordship. As per, that is also, Lordship, point, Lordship. As per office member, they have to give the full payment of the, which was drawing by the disease, Lordship. But they are giving half to me. That is also as per latest office member 2017. It was given effect from what that 2017 last paragraph you have read.
Yes, yes, yes.
2017 or 2017 or
Mm,
that was
18 and
2017, but this person was died in 2016. So this office member does not cover my case, Lordship. And there is specific direction from the court to appoint me, Lordship, relaxing my overage and qualification, Lordship. There is specific direction. So they cannot, Lordship, interpret the order other way without any, Lordship, review or appeal or any leave from the court, Lord. There is specific direction, Lordship. The secretary to the government in the Department of Education shall place the case before the next meeting of SLC for compassionate appointment, a place for her compassionate appointment, considering her eligibility in any grade 3 post, being a master degree holder in Assamese, relaxing her overage. So there is direction from the court to relax the overage. So they cannot send to the personal department or other way to relax. There is a order from the court to relax the age.
My lord, as per order, my lord, secretary has placed the matter before the next SLC meeting, and as SLC has their view that the matter may be placed before the personnel department, and personnel department will see that the matter may be condoned or not, my lord. Yeah. So, my lord, and as per here, it is not made the party of SLC. SLC represented by the director.
Last paragraph 18 of the order.
So
After
it
his
is the view
decision
of
that
SLC,
one
my
minute.
lord.
After his decision, the state level committee for appointment commercial intimate the petitioner regarding her claim for appointment compassionate ground.
So let's let them intimate me that my case was before the SLC. When I visited the office, they only stated that SLC meeting is not held. It will be held shortly. Then I have to file lordship RTA application. There also no information was lordship given. When I visited the office last time, only I have on 10 lordship, 21, 10, 24. When I visited the office, I was handed over this lordship letter. Let them show when they inform me that the SRC are rejected. Then I had approached this honorable court lordship again. They did not inform me. There is order from the court to intimate the decision of the lordship, decision regarding my appointment.
My lord, SLC is headed by the.
Go the SLC, and SLC has appointed use of personnel department may be obtained.
Yes.
And you have not placed the matter before the personnel department.
No, my lord, here
You come to your order.
as per recommendation of SLC Department of School Education, took necessary steps to take decision on the S condonation on the basis of standing office memorandum of personnel department and also obtain the views of personnel department, madam. So that the matter can be placed before the SLC meeting on next meeting. But in the meantime, personnel department issued office memorandum so and so directing all the departments ABP.104/2024/90 dated 18/9/2024.
The matter
Directing all.
not placed for the personnel department. Right?
Yes. But my lord, in the meantime, they have issued the office memorandum here.
Office memorandum has not
And
given the
the who have stated so is applicable only those persons who have died in harness after 31/3/2017.
Cases not known to known prior to 31/3/2007. And he submitted application 25/5/2017.
What was the direction of this court?
My lord. Direction was that, my lord. The Secretary to the Government of Assam in the Department of School Education shall place the case of the petitioner before the next meeting of SLC for compassionate appointment afresh. For her compassionate appointment, considering her eligibility in any grade 3 post being a master degree holder in Assamese, relaxing her overage at the time of her application for compassionate appointment in terms of clause 16 of the office memorandum dated 1/6/2015, noted above as applicable.
That's all right. Person to that order, you have placed the matter for the SLC.
Yes.
And SLC has asked you to obtain the view of
Personnel department.
personnel department. And you have not placed the matter before the personnel department. How do you comply with the order of this court?
I know 2 weeks may be granted. I will take the.
2 weeks. How many 2 weeks you have already availed? Can you use that way to circumvent the order of this court? Let the person concerned remain present in
My
the
lord,
court.
sometime may be granted, at least last chance may be granted to place the matter before the personnel department for their views, my lord. One last chance may be granted.
Then even if we grant of 1 week, then you also do the same thing.
My lord, one last chance.
Purpose of it or not. Sir, during the course of hearing for the content contempt of the court, dated 12/3/2025, passed by the Secretary, the Governor of Assam Department of the Court. And purpose of the same indicates that the claim of the petitioner for appointment under competition ground cannot be considered that that is the as the personal fee department by their OM number 80.14 stroke 2020 stroke 19 as direction not to entertain any case of appointment under the competition. Mr. Sharma further submits that pursuant to the order passed by this court, the matter was placed before the SLC. And the SLC has recommended that the Department of School Education shall take necessary steps, take a decision on the age continuation on the basis of standing OM of the personal department and also to obtain leave the personal department so that the matter can be placed to the SLC on next. And it also appears that in the meantime, the personal fee department has OM dated AB OM number A.1 directing all departments not to entertain any case of competition ground appointment, including the case not known prior to 31. And as per the OM, the case of the employment, so the case of the employee who died in harness on 13/7 have been taken care of by company family pensions by number AFP.28. The president of the information order indicates that though the matter was placed before the SLC, the SLC has directed the Department of Security to take up the matter of confirmation of age of the petition on the basis of standing OM to the personal department. But the matter was not placed to the personal department. In view of the OM dated 31/6/2007, thus it becomes clear that the respondent contempt note has not complied with the order of this court. That is, this is a sort of something that is done with 1 week time so as to place the matter before the personal department. There is accordingly allowed place the matter on the one.
Lordship, one thing, Lordship. On the next date, they may be directed to place the minutes of the meeting, Lordship of SLC dated, Lordship. 18/8/2020. Also, as because they have submitted some notes, but the minutes have not been submitted before the court lordship. So we have not able to understand whether the case was placed before the SLC or not. So that's why lordship minutes is
At this
required.
point of time, there is no point for disturbing this committee.
If they have placed
The
the
letter of the joint director. Why should we discuss it about that? September. The letter part for the next part.
Must.
We will resume after 5 minutes.
The transfer of the honorable judge, my lord, who heard the matter, it has been released and it has come up again, my lord, for admission. Now, my lord, before I take your lordship into the merits of the case, I'd like to point out, my lord, there is an SLP pending, which is, my lord, substantially the issue is related to, my lord, this particular petition. What happened, my lord? The petitioner, who is a professor of KK Hendrik University, he was terminated from service without following the, my lord, due procedure laid down by law, without a, my lord, disciplinary proceeding. And that was challenged by this before this honorable court. And this honorable court, my lord, the honorable single judge, had allowed the writ petition, setting aside the termination order. But then, my lord, liberty was granted to, my lord, proceed with the DP, disciplinary proceeding, by following the service rules. Against that order, my lord, the university filed an appeal before the division bench, and the division bench, if your lordship, my lord, kindly comes to order dated order at page 82. Your lordship will find, my lord, the honorable division bench did not interfere with the matter, but then, my lord, university was granted liberty to proceed by giving opportunity to the petitioner without adhering to the service rules. Without adhering to the service rules. By giving, my lord, adequate opportunity. That was the direction of the division bench that your lordship will find, my lord, at page 82. My lord, the operative part at, my lord, page 95. Paragraph 22. Has your lordship got it, my lord? The appellant university is free to proceed against the respondent number 1 writ petitioner, but after providing sufficient opportunity of hearing to him. The appellant university is directed to provide sufficient time to the respondent number 1 writ petitioner to furnish his explanation, reply, and after receiving the same, the proceedings initiated against the respondent writ petitioner can be dropped if the appellant university finds the explanation, reply filed by the respondent number 1 writ petitioner satisfactory. However, if the university decides otherwise, it shall pass a speaking order. Before that, my lord, in paragraph 21, last sentence, your lordship will find that however, the appellant university can very well proceed against the respondent number 1 writ petitioner by providing him sufficient opportunity of hearing without adhering to the procedure laid down under service rules of 2019. My lord, as against that, my lord, an SLP is pending. I think, my lord, the order was placed before the court disciplinary. Now, the respondent university in the SLP has been seeking time, if your lordship sees the last order, 18/7/2025, in view of the letter circulated by the learned counsel for the respondent seeking adjournment for filing counter affidavit, the matter stands adjourned. The last adjournment was 18/7/2025. My lord, the 4 weeks time have, my lord, elapsed, and the matter will come up for final hearing at any point in time.
Now, my lord, why I am pointing out this, my lord, in the event the repetition, my lord, the SLP is allowed, then, my lord, this hearing of this matter will be, my lord, not necessary. There are two possibilities, my lord. The SLP may be allowed or rejected. In the event it is allowed, my lord, this matter need not be heard. In the event, my lord, that is, my lord, rejected, then also, my lord, this petition, and then, my lord, survive. Therefore, my lord, I am otherwise ready for hearing. I am pointing out that, my lord, the time that will be taken up for, my lord, this hearing, that may be, my lord, unnecessary. That's why perhaps we can wait for some time, my lord, because the Supreme Court will take up the matter very soon.
My lord, if my learned friend's argument is to balance the equities, then my lord, lordships will allow our IA vacating the interim order, and depending upon the Supreme Court's order, consequences will follow. Now, my lord, kindly take the IA.
No, my lord, in that event,
No,
my lord, I'll argue the case.
no, it's my IA.
I'll argue the case.
No, it is my IA. I'll move the IA.
IA was, my
Today-
lord, disposed of along with the, I mean, made final, my lord, reserved for final judgment. Thereafter, it has been released. In that event,
The matter has come because of the IA.
no, this matter has come because, my lord, it has been released by the honorable judge who heard the matter finally, and, my lord, made it CAV. Now, my lord, here is a case where the university takes time there in the, my lord, Supreme Court, and here they want to hear the matter. My lord, I'm ready. I'll argue the matter.
My lord, here is a case. They will file petition in High Court. They will file petition in Supreme Court. Here is a case. What they did, my lord, pursuant to the division bench order, my lord, this petitioner, he was an, my lord, PRO in railways, NF Railway. He is not a faculty member. He got his, my lord, doctorate at 1 year ahead of his appointment. Now he gets an appointment because his friend is the VC of that university.
That is not
and
the
that
pleading.
VC has been sacked from service.
That is not in the
That
pleading.
VC has been sacked from service.
That is
Now,
not
my
in the
lord,
pleading.
now, my lord, if we are to apply this service rule, then we'll treat him that he is a member of the faculty of the institute. No. That's why division bench said, my lord, by giving him, procedural safeguard, by following the rules of natural justice, complete the inquiry. Now, my lord, the issue is why he came to this honorable court. I'll just, if your lordship would kindly take the IA
Then
for
I'll
1
argue,
minute.
my lord. I'll argue, my lord.
No,
My
I'll
equity.
show your conduct.
I'll argue my
That is why I want
no,
to show.
Don't question my conduct.
Yes.
The SLP subject matter is different, my lord. This is not identical. This is substantially same because, my lord, if it is decided, this may not be required to
My lord,
decide here.
SLP is against what? SLP is against the division bench order. Division bench says you proceed, but the service rule will not apply. Supposing tomorrow Supreme Court dismisses their SLP, therefore the best thing is to allow to proceed, my lord. Depending upon the outcome of the Supreme Court, university will take a call.
Let me place my case, my lord. I am the petitioner here. Now
I have failed to understand one thing. Can a litigant at the same time simultaneously approach High Court and Supreme Court? That's the first point to be decided.
It's not against the same order. It's not against the same order, my lord. I'll place the facts before your lordship, my lord. They want to delay the matter in the Supreme Court. They want to, my lord, make this matter hard, my lord. I'm ready to do the hearing. Your lordship will kindly take up my writ petition.
If the subject matter pending the report in the SLP is same with the present,
It's not same, my lord. It's not same. The, my lord, honorable single judge allowed my writ petition. The order of termination was set aside. However, my lord, liberty was granted to proceed if the, my lord, the university desires to proceed in accordance with the service rule. Against that, my lord, in the writ appeal, it has been said that you need not go into the service rules, give him opportunity. So I am aggrieved by that part of the order of the division bench, which says that without resorting to the service rules, you can conduct an inquiry. That is the matter pending before the Supreme Court. Here, my lord, what happened after the, my lord, the division bench order, they have now proceeded in such a manner that, my lord, a committee wants to, my lord, the examine my suitability for the post, which was, my lord, I was selected by a rigorous process of selection by following the, my lord, the UGC guidelines and the my lord, statutes of the university. Now a committee, which is, my lord, comprised of some members of the managing, my lord, the board of management, they have formed a committee. That committee will give a report. Report will be, my lord, placed before the board of management, where, my lord, the members of the committee are also members of the board. So, my lord, the board of management and the committee will be, my lord, a judge, jury, and executor. This is my case, my lord. Therefore, it does not have any direct relation with that, with the SLP. In the event the SLP allows, this may not be heard, because if the court says, my lord, Supreme Court says that you proceed in accordance to service rules, then, my lord, this procedure will go. Now, I am challenging your procedure after, my lord, division bench order. You have issued certain notice, formed a committee, and committee members are such that they are also the, my lord, members of the board of management. So they give a finding here in the committee that will be placed before the board of management, and the board, my lord, board of management, same members, and they will approve it. So, my lord, your lordship will see the attitude, the manner in which they are proceeding against me from the very beginning. I am, my lord, going to, my lord, bring to your lordship's notice. But these two are not identical, my lord. There is a difference between being identical and, my lord, issue being substantially same. Issue is to some extent substantially same, to the extent that, my lord, in the event the SLP is allowed, then, my lord, this matter becomes infructuous. That's why, my lord, since your lordship will hearing the matter, I'll place my case.
If there be conflicting decision of this court, that of the court.
No, there cannot be a conflicting decision, because they are adopting a procedure without following the service rules. If the Supreme Court says follow the service rules, fine, it will go. If the Supreme Court says no, you need not go into the service rules, then this procedure will, my lord, take place. And that's why, my lord, I am challenging this procedure they are adopting. May I please the facts, my lord?
Okay, then IA and the
No, my lord, no,
here both the method.
no, my lord, IA should be hard. If your lordship kindly have a look at the IA for a
My lord,
moment.
your lordship will kindly see.
Why my learned friend is saying that?
Your
my lord?
lordship will see the orders passed in the IA earlier, my lord.
No. What I am saying is I am to show his conduct. No, please come to the IA for a moment. Kindly have a look at. Yes. Please come to. No, just 1 minute. my lord. Yes.
Your lordship will see the
My learned
orders that
friend
have been
cannot
passed in
prevent
the
me
IA
from
earlier.
placing my case. Please come to page 40, my lord, of the IA. Yes, IA and the writ petition were heard together. That is over now. That has become history. Page 40, my lord. In pursuance of the judgment, the order dated passed by the division bench of the High Court in writ appeal number so and so, and subsequent decision of the Board of Management in its 77 meeting, by resolution held on 10/6, I am hereby directed to inform you to furnish your explanation reply within 30 days from the date of receipt of this communication in response to your earlier show cause notice, which was issued by the then registrar and duly served upon you. So, my lord, pursuant to the division bench order, we said, please come forward and furnish your reply, explanation. Then please come to page 41, my lord. With due reference to the above, in pursuance of the judgment and order dated as passed by the division bench of the Guwahati High Court in writ appeal number so and so, and subsequent decision of the Board of Management in its 77 meeting held on so and so, you are requested to appear hearing before the committee constituted for the purpose at 2:30 p.m. because, my lord, he doesn't have the qualification. Therefore, an expert will take a call whether he has the required qualification. Now, kindly see his reply, my lord. That's why I was saying his conduct needs to be seen. 7/8/24. With due respect, I would like to bring to your notice that my 42 my lord,
Got it.
my only child, Kabir Sharma, has a psychological breakdown last night following suicide by one of the students in USTM Meghalaya, where my son is also studying. He is currently in need of constant observation and support. Kabir had earlier been diagnosed with OCD in 23 and is under treatment of doctors at LGB, Regional Institute of Mental Health. As my wife is a working mother and cannot avail leave beyond today, I have no option but to take leave from my current responsibilities from so and so to so and so. In view of above, it will not be possible for me to attend the hearing before the committee as mentioned in your letter mentioned above. I therefore request you to kindly grant me at least one last chance of appearing before the committee on a date convenient for you after 15/8/24. So it was a very innocuous letter, my lord. Now what he did, my lord, he filed the writ petition. after filing this petition. That's why I said look at his conduct. Then, my lord, his review petition was also pending on that day. Against the order in, my lord, writ appeal, a review was filed. The review has been dismissed. What are they? There was delay of 28 days in preferring the appeal, my lord. This honorable court not only, my lord, please come to para 4 of the order. Having heard the learned counsel appearing for the applicant, and after going through the material available on record, we are of the view that facts of Sandeep Kumar are quite distinguishable from the facts of the case of the applicant review petitioner herein. In case of Sandeep Kumar, Institute had terminated the service of incumbent while relying on the minutes of the meeting of the Board of Governors held on 16/6/18. However, the Honorable Supreme Court found that in the said minute, no such observation regarding qualification, etc., of the incumbent had been recorded, and as such, reliance placed by the Institute on the said minute of the meeting was erroneous. In the present case, no such situation is there. Hence, we do not find any case for review. In these circumstances, this interlocutory application and connected review petition are dismissed. My lord, that review petition was pending. Despite that, this writ petition was filed. Now, Supreme Court is also pending. How? Why your lordship will permit, my lord? Either he pursues this petition or withdraws the Supreme Court, or he pursues the Supreme Court matter and withdraws this, or else lordship will dismiss it by awarding cost. He cannot do all these things, my lord. The moot question is he doesn't have the qualification. So, university has appointed a committee to examine of experts whether he possesses the qualification. My lord, there are two ways a person can be recruited. Either you are a faculty, or you are a man having exemplary, knowledge over the subject. Now, he was a public relation officer of NF Railway. He got his PhD on 1 year ahead of joining the university. Subsequently transpired that he is not eligible. So we want to assess his eligibility. That's all, my lord. Why this? My lord, this is at end of the day 226. My lord, it's a discretionary jurisdiction. It's not a case where lordships would like to invoke the extraordinary jurisdiction of this honorable court. Admittedly, his claim is tainted with illegality. Therefore, my lord, this writ petition is liable to be dismissed with cost. He cannot pursue remedies like this. Review petition pending that you do not disclose. You file a writ petition. You tell the authority, my son is ill, give me last chance. Why have you not pointed out all these things in your representation? That the body constituted is biased towards me? We'll change everybody, my lord. We'll change all the members of the board if he's having any bias against, if he considers that there's any bias. This is not the way, my lord. Therefore, my humble submission is, it's a case where lordship will consider my interim prayer. If my learned friend is having any difficulty today, lordship can have it tomorrow, day after tomorrow,
No, I don't.
or any other convenient date, my lord.
I don't.
But IA has to be considered first.
I don't have any
Because he's getting a salary of almost 3 lakhs per month, my lord, which is not eligible. At the end of the day, these are all public money.
Now, may I please my case? That is my history.
We will dispose of both the IA and the writ petition.
Okay, my lord.
Or that.
Okay. Okay.
So, totally, you please argue.
The first thing is, my lord, he is not getting a salary of 3 lakhs. He is getting about 1 lakh and 1 mile. This is not correct.
My lord,
Anyway,
my lord, can I make one submission? Let my learned friend do his part. I'll give my reply tomorrow, day after tomorrow, my lord. Yes. Let my learned friend conclude. Yes. Deep level.
Yeah.
May I take your lordship to the advertisement first, my lord, which your lordship will find at page 27. There was an advertisement by the KK Handik State Open University. May I read it, my lord? Applications are invited from the Indian citizens. Has your lordship got it, mate?
Got it.
Page 27. Applications are invited from the Indian citizens for the following posts. Number 1, Professor, so-and-so, so-and-so. Number 3 is relevant, my lord. Professor under Bhupen Hazarika School of Mass Communication. Now, your lordship will see there are, this advertisement comprises of, my lord, posts other than the post held by the petitioner. My lord, other posts are there. So, my lord, all this, the selection process was held in the same manner as that of the petition. That is important, my lord. Why it is important, I'll, my lord, bring to your lordship's notice a little later, my lord. Now, my lord, I'd like to draw your lordship's attention to the procedure of selection. The procedure of selection is guided by two things, my lord. One is the first statute of the university, and the other is the, my lord, guidelines of the University Grants Commission. In here, my lord, 2018 regulations of the UGC are applicable. I'll first draw your lordship's attention to the, my lord, status of the university that your lordship finds at page 28. 49. Yeah. Anyway. Now, my lord, your lordship will find this is an extract, my lord. Qualifications. Your lordship will find the qualifications for various posts of teachers shall be fixed by the Board of Management on the recommendation of the Academic Council from time to time in consistence with the recommendations appropriate commission committees. Now, the manner of importance, this is important. The university shall advertise the post with such qualifications as have been prescribed in the ordinance. Then sub-rule 2, B2 is important. The applications received against each post shall be sent to at least 2 outside experts not connected with the university for assessment of their eligibility for the posts. Now, my lord, they start the first scrutiny by sending the, my lord, particulars of the, my lord, the candidate to some outside experts for what? For assessment of their eligibility. This is important, my lord. So it goes to 2 experts. Then 3, if the list of applicants recommended by outside expert is big enough, the Vice Chancellor shall have the power to short the list of such candidates. And my lord, here the case was that, my lord, the list was not big enough. So, my lord, the shortlisting was not there. So, my lord, B2 is important. Now, my lord, what they did, my lord, as per the statute, they had sent it to, my lord, 2 experts. And your lordship will kindly see the assessment report of the petitioner by the 2 experts that your lordship will find at page 30. Why I am showing all this, my lord? He was selected through a proper, my lord, selection process. Now they want to, my lord, question my eligibility, which eligibility has already, my lord, gone through all these rigors. That is why, my lord, I am pointing out. My lord, taking advantage of the division-based decision, my lord, they don't want to resort to the service rules. They want to take a shortcut and, my lord, say that I am not eligible. Now, my lord, how my eligibility was assessed, your lordship will find page 30. Assessment from subject expert. Background information. Name, Dr. Jayanta Kumar Sharma. Now, your lordship will find professional career, very good. Teaching in industry experience, very good. Quality research, excellent. Range of research, good. Quality of publication, good. Contribution to knowledge in distance discipline, good. Overall assessment, good. Then, my lord, your lordship will come to the second, the next, my lord, after the chart. Do you recommend the candidate to be called for interview? Yes. Your assessment about the candidate. Although the applicant does not have the required teaching experience as assistant and associate professor and has not supervised research at the PhD level, his experience in the industry and his contribution to the knowledge in the domain qualifies him to be considered for the post of professor under clause 4.1.3.b of the UGC regulation 2018. My lord, I will draw your attention to that. So, my lord, this has been sent by one Professor V. Krishna Anand of Sikkim University. He is not connected with the selection process. Only thing, my lord, the credentials, my lord, documents of the petition were sent to him, and he has given the report that he is eligible to be considered. Then your lordship may kindly come to page 32, the other expert. The other expert is, my lord, one Professor Ram Mohan Pathak from Prayagraj, the Nehru Gram Bharati deemed to be University, Prayagraj, UP. There, my lord. Last but one paragraph, your lordship will find your assessment about the candidate, the performance of the candidate in the core subject area and applied field is applicable as per norms advertisement UGC regulation, he is eligible under category B to be called for interview. This category B and my lord, the clause 4.1.3.b, these are important, my lord. I will draw your lordship attention to that. Then your lordship may kindly come to page 30, my lord. 35, I'm sorry, 35. This is the proceeding of the selection committee. So, my lord, two experts say that he is eligible. Then, my lord, his case was considered. And this is the, my lord, proceeding of the selection committee, where, my lord, Vice Chancellor is the chairman. One member, Dr. Indra Kumar Bhattacharya, Professor Hemchandra Gautam, Professor V.K. Anand, Professor Abhijit Bora. These are the two experts. Now, there are two candidates. The two candidates were shortlisted and called for interview, out of which two candidates appeared in the interview. The committee, after taking into consideration the academic credentials, experience in open distance learning, research publication, and performance in the interview, unanimously decided to recommend the following candidate for appointment in order of preference: Dr. Jayanta Kumar Sharma. So, my lord, only one person was selected, petitioner was selected. Now, he has been communicated. Appointment letter is at page 36. He was appointed, and my lord, that there was a probation period for 1 year. Clause 5, your lordship will find the probation. Subject to the provisions in the statute, this appointment is made on probation for a period of 1 year from the date of joining. However, the appointing authority shall have the power to extend the period of probation. This offer of appointment may be withdrawn at any time during the probation period based on administrative reasons. So the other parts, my lord, your lordship may skip. Accordingly, my lord, the petitioner has joined. Now, after 1 year, my lord, page 38, your lordship will find 11/3/2022. He was appointed on, my lord, 24th December 2020. Then, my lord, in 11/3/2022, this order has been passed. As per approval of the Honorable Vice Chancellor, the service of Professor Jayanta Kumar Sharma, Director, Bhupen Hazarika School of Mass Communication, is confirmed with effect from 1/2/2022. So, my lord, he has been confirmed in service. Now, what happens, my lord? Very strangely, if your lordship comes to page 39, this communication was issued after, my lord, confirmation of service to Dr. Jayanta Kumar Sharma. Sir, in response to the letter number such and such dated 22/12/2023 from the UGC New Delhi, a committee was constituted to examine your eligibility as professor in Bhupen Hazarika School of Mass Communication. The committee submitted its report, which was presented before the Board of Management in its 70th meeting held on 10/3/2023. The board resolved that the action should be taken against you based on the recommendation of the committee. I am directed to know your opinion. I am stressing on this word, my lord, opinion, about the decision of the committee and the Board of Management within 10 days from the date of issue of this letter. Now, my lord, your lordship will see there has been, my lord, a committee constituted behind my back. I have not been, my lord, associated with that. That committee has, my lord, given some finding. And, my lord, on that basis, my lord, they want my opinion on the, my lord, recommendation of the committee. Now, your lordship will kindly come to the report of the committee. Page 40. Dr. Jayanta Kumar Sharma was appointed as professor in Bhupen Hazarika School of Mass Communication, KKH and he joined in the university on 1/2/2021. His service was confirmed after completing his probation period on 31/1/2022 in the 66th Board of Management meeting. Prior to joining the KKSOU, the Jayanta Kumar Sharma was working as public relations officer in the NF Railways since 2001. He is an MA in Mass Communication and PhD from Faculty of Fine Arts, Communication and Journalism, Guwahati University. 2 is important, my lord. After joining the university, various queries, RTIs regarding appointment of Jayanta Kumar Sharma have been received. Deputy Secretary Governor Assam has forwarded a copy of the petition addressed to the Honorable Chancellor, which was submitted by Sri Bolen Boisho, President Hindu Yuva Chhatra Parishad, political party, political outfit, regarding alleged gross anomalies in selection and appointment of Sri Jayanta Kumar Sharma as professor. Now, Additional Secretary to the Government of Assam, Chancellor of Secretariat, had forwarded a copy of the petition dated September 13, 2022, addressed to the Honorable Chancellor, submitted by Professor R. Medhi of Kalapahar, Guwahati, regarding alleged irregularities in the appointment of Sri Jayanta Kumar Sharma as professor. Deputy Secretary UGC, New Delhi, has also endorsed a copy of the letter received from Deputy Secretary, Ministry of Education, forwarding a complaint of Professor S. Burua, reference number so and so, requesting for immediate action against unqualified professor appointed during 2021 by Dr. Kondorpa Das, the then Vice Chancellor of KKSSU. My Lord, I deny that, my Lord, Professor S. Burua, Dr. Srinath Burua, he had not made any complaint against us. I have got that document. I'll please before your lordship. This has been, my lord, misrepresented here. Nevertheless, my lord, your lordship need not go into the entire report. Then, my lord, eligibility criteria has been, my lord, discussed at page 42. And this is very important, my lord. I'll refer to the UGC regulation also in this context. Eligibility criteria for the post of professor as per 7 CPC. While the aforementioned UGC regulation 2018, while clause 2.2, the UGC had specified that the minimum qualification required for the post of assistant professor, associate professor, professor, and other posts shall be as specified by the UGC in the regulations. Further, while clause 3.2, with regard to the qualification, it had specified that no person shall be appointed to the post of university and college teacher, librarian, or so and so in any university or any institution, including constituent or affiliated colleges recognized under Section 2 of the UGC Act, or in an institution deemed to be a university. Then your lordship may skip, my lord, the eligibility. This is the, my lord, most important part. For eligibility as professor, there are 2 clauses, clause A and B. So far as the petitioner before your lordship is concerned, my lord, he fulfills B. And A is for, my lord, other academicians. A, an eminent scholar having a PhD degree in the concerned allied subject discipline and published work of high quality, actively engaged in research with evidence of published work with a minimum of 10 research publications in the peer-reviewed or UGC listed journals and the total research. So, my lord, this your lordship may skip because, my lord, I do not fall under this. I fall under B, and your lordship will notice, my lord, there is a difference. My lord, it has been segregated by or. So you have to have the eligibility either A or B. Now, my lord, I am coming to B. An outstanding professional having a PhD degree in the relevant applied discipline from any academic institution not included in A above / industry, this is important, who has made significant contribution to the knowledge in the concerned allied relevant discipline, supported by documentary evidence, provided he or she has 10 years of experience. Accordingly, for appointment of professor, my lord, this is the eligibility, my lord. I have annexed the documents to show that, my lord, I fulfill B. And that is the, my lord, finding of the, my lord, two experts, and also the selection committee has, my lord, followed that. Now, your lordship may skip the other discussions for the time being, and eventually, my lord, what is the recommendation of the committee? Conclusion, your lordship finds at page 48. Based on the above observation, has your lordship, based on the above observation, the committee is of the opinion that Dr. Doyendra Kumar Sharma did not fulfill the eligibility conditions for appointment to the post of professor at the time of selection. Committee also observed that there was deviation in the selection procedure and lack transparency, which require enough checks and balances so that such instances do not occur in future. The committee is thankful. So and so, your lordship will kindly also notice that, my lord, there are three persons named there. Mridul Hazarika, he has signed it. Dr. D.K. Rao signed it. But Professor Munish Kumar has not signed it. So they were the, my lord, committee members, and two of the members have signed it. My lord, shall we resume at 2 o'clock now? 1:05 now.
Sir,
I was just pointing out. Now, what happened, my lord? Is your lordship has seen, my lord, the my lord, ultimate the recommendation. Then, my lord, the petitioner at page 49, your lordship will find that to give his opinion, because my lord opinion was short, he wrote this letter. I mean, receipt of the letter under reference. I have also received the photocopies of two letters from the UGC addressed to you and photocopies of the 9-page report of the Commission on examination of the selection procedure and eligibility of Professor Jayendra Kumar Sharma sent along with your letter referred to above. Please take note that those photocopies have not been authenticated to be copies of the original documents. There have been a reference to a number of annexes in the said report which have not been provided to me. The photocopies of the documents provided to me may kindly be provided again, duly authenticated. Also kindly provide me with the duly authenticated copies of annexes 3, 4, 5, 6, 7, 8, and 11 so that I can submit an informed and reasoned opinion. Because it was opinion, it was not a matter of show cause notice, my lord, why action should not be taken against you. About the decision of the committee and board of management at sought for you. Moreover, you have informed that the Board of Management of KK Hendrik University resolved that an action be taken against me based on recommendation of the committee. I may also be provided with an authenticate copy of the resolution of the Board of Management. So, my lord, he asked for these documents. Against that, my lord,
where is that letter by which the university has sent a report?
university has sent the report on, my lord, that is at page
Forwarded the report to you. Where is that letter?
39, my lord. Page 39. Page 39. They forwarded the report and asked for my opinion. Page 39.
Okay.
The committee was constituted. Then I am directed to know your opinion about the decision of the committee. So it was not a proceeding matter as such. A committee has been constituted behind my back, my lord. It has made some report without, my lord, taking any statement or without informing me. Then, my lord, they recommended that, my lord, I do not have the eligibility and I am asked to give my opinion. Then against this, my lord, communication dated 3/4/2023 at page 39, my lord, I had written this letter at page 49. Provide me with the document, authenticated documents, so that I can give my opinion. Now, what happened, my lord? This is on 4th of April. On 18th of April, They provide me the documents. And on 19th of April 2023, my services have been terminated. So before I could provide my opinion based on the documents, they had, my lord, provided it on 18th of April 2023, and without waiting for my lord, consideration of my response, my lord, on 19th of April, I was terminated from service. Your lordship will see what is playing in the mind of the, my lord, persons in the HMO affairs of the university. So, my lord, challenging this order of termination, your lordship will find at page 50. Office Order 19/4/2023, in pursuance to the decision of the 71st meeting of the Board of Management held on 19 April 2023 by the resolution number so and so, and on the basis of the report submitted by the committee constituted for examination of the selection procedure and eligibility of Professor Jayanta Kumar Sharma, the service of Professor Jayanta Kumar Sharma, Professor in the Bhupan Hazarika School of Mass Communication, Krishna Kanta, Handigo State of Bonibri, is terminated with immediate. So before I could, that is, my lord, before I could respond to the notice asking for opinion. So, my lord, this was challenged before this honorable court, and the judgment of this honorable court, your lordship finds at page 51. Your lordship may skip the discussion and come to page 80 of the judgment of the honorable single judge in the earlier petition. Relevant paragraph, my lord, paragraphs 57 and 58 and 59. May I read that, my lord?
Yes.
Having considered the materials on record and in the light of the above discussion, I hold that the Service Rules 2019 would be applicable, which has not been adhered to at all by the respondent university. Therefore, the termination of the service of the petitioner is in total violation of the procedural requirements prescribed under the Service Rules 2019, which expressly provides the cardinal principle of natural justice. The petitioner is entitled to an opportunity of hearing in terms of Service Rules 2019. The procedures are clearly prescribed under Rule 19 of the Service 90 of the Service Rules 2019, and the same has been violated with all impunity, and the petitioner, a confirmed regular employee, has been terminated illegally. The non-compliance of the mandate of Rule 90 of the Service Rules 2090 is an infirmity which goes to the root of the matter and without more vitiates the action of the respondent university. In view of the discussion made herein above, I am of the considered view that the impugned termination order dated 19/4/2013 has been issued without following the principles of natural justice, which is otherwise expressly provided under the Service Rules 2019 and without any reference to the said provision of rules. Thus, the impugned order dated 19/4/2023 cannot be sustained. Accordingly, the impugned termination order dated 19/4/2023 issued by the registrar KKHSOU terminating the service of the petitioner as professor in the Bhupan Hazarika School of Mass Communication of the university is hereby set aside and quashed. Consequently, the petitioner, namely Jayanta Kumar Sharma, be reinstated forthwith as professor in Bhupan Hazarika School of Mass Communication with all consequential benefits. However, this respondent university is at liberty to proceed with the departmental proceeding against the petitioner strictly in terms of the Service Rules 2019. Against this order, my lord, I was reinstated. I'm working still, my lord. They filed the writ appeal. And in the writ appeal, my lord, the finding is page 95. It starts at page 82. Relevant is page 95. Paragraph 21. In view of the above discussion, we have no hesitation in holding that the learned single judge has not committed any illegality in setting aside the termination order dated 19/4/2023 issued by the registrar of the university, terminating the service of the respondent number 1 read petitioner as professor in Bhupen Hazarika School of Mass Communication, and has rightly ordered for reinstating the respondent number 1 read petitioner in his service forthwith on the said post with all consequential benefits. However, the appellant university can very well proceed against the respondent number 1 read petitioner by providing him sufficient opportunity of hearing without adhering to the procedure laid down under the service rules of 2009.
That's why.
That's why, my lord, we had
So, you have been elected, appointed, following due process of law.
Right.
You have also been confirmed
Right.
as the professor of that.
Right.
Therefore, why the service rules should not be applied?
That's why we are before the Supreme Court, my lord. That's why we are before the Supreme Court. We say, my lord, that by giving this, my lord, you are giving them a free hand to go for my assessment again, my lord. The assessment, my eligibility, my credentials, that has already been, my lord, gone through my lord, the rigorous process. Thereafter, the university has selected me. University has, my lord, confirmed me. And thereafter, on the, my lord, complaint of some, my lord, political outfit, you terminate me without giving any opportunity. This honorable court has set aside that order. The division bench has upheld that order, but then, my lord, it said that you may not resort to the service rule. This is, my lord, difficult to understand, but, my lord, we filed the review. Review was also rejected because, my lord, when this judgment was, my lord, the writ appeal was heard, and before it was, my lord, delivered, there was a judgment of the Supreme Court that we placed, my lord, that has also been discussed in the, my lord, review. Because that stage, my lord, service rule has to be adhered to, but then, my lord, the division bench did not agree to that, distinguish on fact, and therefore we are in the, my lord.
No, but that's very different. Actually different. But the question is,
That's why, my lord, the
confirmation of service. Why service not be applied?
That's why, my lord, initially I submitted, my lord, the entire hearing process will, my lord, in fact, depend on what the Supreme Court finally says. Supreme Court, if the Supreme Court says that, my lord, you have to resort to service rule, then, my lord, this matter need not be heard. Because in that event, my lord, they have to issue me a, my lord, show cause notice under the rules. Then, my lord, all the procedure of the disciplinary proceeding has to be followed. So this will become infrastructure. But then in the event, my lord, the SLP is dismissed, then, my lord, I can argue why, my lord, this cannot be done. Without, my lord, resorting to even service rules, my lord. Because what they are trying to do here is that, my lord, they constituted a committee where, my lord, out of 5 members or 6 members, 3 members are from the Board of Management. They will, my lord, assess my eligibility and my suitability, my qualification, which was already done, and they will submit a report to the, my lord, Board of Management. And these same persons who are there in the, my lord, the committee, they will also be there in the, my lord, Board of Management. That is the, my lord, primary ground of challenge in this writ petition. Therefore, my lord, the SLP and this has no direct relation as such. But then, my lord, decision of the Supreme Court will, my lord, may affect this decision. That's why I said, my lord, why should we, my lord, the valuable time of the court should be, my lord. But then, my lord, he insisted on the IA. So better, my lord, I argue the entire matter. So I'll, my lord, place before your lordship, my lord, why that cannot be done. Why such a committee cannot be constituted, and why, my lord, my eligibility, my suitability cannot be assessed again, my lord, after I have gone through all the, my lord, the rigors of the selection that has been mandated by the UGC guidelines and the. This is briefly my case.
Let's go from
My.
yes.
My lord, we last came to the order of the division bench. Why, my lord, these rules are not to be followed? That is not an issue, my lord. We can agitate before your lordship now, my lord.
Yes.
That for the, my lord, Supreme Court to decide. But, my lord, before reverting to other submissions, my lord, I'd like to point out that, my lord, submission was made regarding the conduct of the petitioner. That he is here, he is in the Supreme Court, he was in the review, it was not informed. At the same time, your lordship will see the conduct of the, my lord, university. In the SLP, my lord, I have placed 2 orders showing that, my lord, they are asking for time. If they want the matter adjourned there, and they are over enthusiastic to, my lord, do this case. Although, my lord, the decision in the SLP in earlier point of time would have been helpful. Nevertheless, my lord, since we have, your lordship has gone into the merits of the case, my lord, may I now take your lordship to page 100?
Page?
100, my lord. This is a notice issued to the, my lord, petitioner by the university, the registrar in charge. Subject rescheduling of hearing before the committee as per your request by the letter dated so and so. Now, my lord, the question was also raised about the, my lord, petition that the petitioner has filed before the authorities asking for time, as if, my lord, son being sick is, my lord, something which should not happen. Nobody knows, my lord, when one gets sick, my lord. Now, your lordship will kindly read the content. With reference to the above, and as per directive of the committee meeting held on 9th and 10th August 2024, I am directed to inform you that the committee has rescheduled the hearing on 9 September 2024 from 11 a.m. onwards, as per your request dated 7/8/2024. Now, this part is important, my lord. The committee desires you to appear for the hearing with all original documents, including certificates, mark sheets from HSLC to PhD, along with experience certificate, original PhD thesis, and other relevant documents which you had enclosed with the application for the post of professor. So, my lord, the petitioner has been asked to, my lord, produce all the documents. Now, if your lordship comes to the, my lord, next, the resolution of the, my lord, of the Board of Management, I have given the extract, my lord, page 101. Item number 23. Resolution number such and such resolved that, my lord, item number 23. To discuss and decide the matter relating to decision of the divisional bench of the Honorable High Court for reinstatement of Dr. Jayanta Kumar Sharma in the post of Professor, Bhupen Hazarika School of Mass Communication. The board was apprised that Dr. Jayanta Kumar Sharma, Professor, Bhupen Hazarika Institute of Mass Communication, was terminated from his service on 19/4/2023 as per board resolution in its 71st meeting. Dr. Sharma filed a writ petition before the Honorable Single Judge of the Guwahati High Court. On 15/3/2024, in the Honorable High Court, a judgment was passed to reinstate Dr. Sharma as professor with all consequential benefits. On the basis of opinion of the legal counsel, the university then appealed against the judgment in the Honorable Division Bench of the Guwahati High Court. In its verdict on 22/4/2024, the Honorable Division Bench of the Guwahati High Court has directed to provide sufficient time to Dr. Sharma to furnish his explanation reply, on the basis of which a decision can be taken on this case. The university, as per directive of the Honorable Division Bench of the Guwahati High Court, reinstated Dr. Jayanta Kumar Sharma in the post of Professor Bhupen Hazarika School of Mass Communication. Following the directives of the Honorable Division Bench, Dr. Sharma is to be given a notice providing him sufficient time to furnish his explanation reply. The board was requested to direct as regards to how much time to be allotted to Dr. Sharma. The matter was placed before the board for discussion and decision. The matters discussed in the members discussed the matter in detail, and after threadbare discussion, the following resolution was adopted. Resolution number such and such, the board unanimously decided that 30 days is sufficient time and resolved that a show cause notice be given to Dr. Jayanta Kumar Sharma by giving 30 days time to furnish an explanation reply. Further, it was directed by the board that a committee be constituted to examine the explanations submitted by Dr. Sharma. Accordingly, the following committee was constituted by the board. Now, your lordship will see the constitution of the board. Number 1, Professor B.L. Chaudhary, Member, Board of Management. Professor L.K. Nath, Member, Board of Management. Professor Prahlad R. Joshi, Member, Board of Management. Then on UGC official, existing or retired, 1 subject expert, then Deputy Registrar Administration as convener. No matter pursuant to this committee was constituted at page 103. By the, my lord, the said members, 3 members of the Board of Management, Deputy Registrar is, my lord, the convener, 1 subject expert, and 1 UGC officer. Now, your lordship, before going further into the case, my lord, I'd like to draw to your lordship's attention one aspect of the, my lord, report of the committee. That will be important for, my lord, for a decision, because here the case is whether, my lord, the question is, my lord, regarding suitability or eligibility. My lord, may I please the resolution, my lord, the UGC regulation 2018, and my lord, refer to the committee report. Now, my lord, I'll refer to page 44. Before that, my lord, your lordship will kindly take up the, my lord, UGC regulation 2018. Here, my lord, the qualifications regarding direct recruitment of professors has been, my lord, given. Eligibility A or B. Down below, my lord, page 59 of the, my lord, UGC regulation 2018. I have given the extra paper, my lord, and I'll refer to page 44.
Right number?
Second page, my lord. Second page of the UGC regulation, that sounds, my lord. And so it will be the third page, Roman 3, down below, eligibility of professor. As I also got in, my lord. Internal page of the my lord, UGC regulation is page 60, clause Roman 3, professor.
Yes.
The professor eligibility A or B. Now, as I have already, my lord, submitted with your lordship, my lord, in my case, B is applicable. an outstanding professional having a PhD degree in the relevant allied applied disciplines from any academic institutions not included in A above, industry who has made significant contribution to the knowledge in the concerned allied relevant disciplines supported by documentary evidence, provided he or she has 10 years experience. This, my lord, I fulfill. I'll, my lord, give my credential. Then your lordship may also like to see the eligibility of A. My lord, so far as A is concerned, my lord, an eminent scholar having PhD degree in concerned allied relevant discipline and published work of high quality, actively engaged in research with evidence of published work with a minimum of 10 research publications in the peer review UGC listed journals and a total research score of 120 as per criteria given in Appendix 2, Table 2. Then number 2, a minimum 10 years of teaching experience in university college as assistant professor, associate professor, and or research experience at equivalent level at the university national level institution. Well, why I am submitting this, if your lordship kindly comes to paragraph page 44 of the writ petition, the report of the committee, they want to, my lord, interchange the requirements of A and B and want to hold me to be not eligible.
Paragraph number?
Paragraph 19. Paragraph 19, page 44.
Page 44.
44, my lord. It starts at page 40, relevant paragraph 19 at page 44. In order to, my lord, make me ineligible or not suitable, they want to bring in the requirement of A, whereas, my lord, I fulfill requirement of B. May I read, my lord, paragraph 19? The assessment report of the experts were based on a format. However, it is not clear who had designed that format, since the registrar or the recruitment cell is not ever of developing such a format. What is striking is that both the expert had mentioned that the two candidates who were actually not meeting the eligibility conditions are eligible to be considered for the post of professor under clause 4.1.3b of the UGC regulation 2018. It raises suspicion on the overall process of screening. Nowhere in the assessment report, screening report, has been mentioned that the assessment screening has to be done after going through the application along with the research publications and other documents. Then the very basis on which the assessment report is based is questionable. In fact, Dr. Jayanta Kumar Sharma had not endorsed sufficient documents to prove that he was teaching or having industry experience, since he had submitted only one research publication and one paper presented in a conference, which are not adequate to evaluate one's quality of research, range of research and quality of publication that form the criteria designed by the university in the format of assessment. The two experts have awarded him either excellent or very good in this parametric, raises a serious questions. Now, your lordship has noticed that here the publication of papers that has been, my lord, thought to be brought in from the requirement of clause A, which is not there in, my lord, clause B. So this is also, my lord, one of the facets of the report. So design is very clear, my lord. Now the question is, my lord, the constitution of the committee. That committee constitutes of 3 members of the board of management, and the report will be submitted to the board of management. Can this be allowed, my? That is my lord, first submission before your lordship. Now, one aspect your lordship will, my lord, notice kindly that my learned friend made a submission that the vice chancellor who was there at the relevant point of time when I was appointed, he was very close to me. And my lord, he was biased in my favor. That is how my appointment has been done. That is a submission he has made. Now, your lordship will kindly take note of the fact that when the petitioner was appointed as professor, my lord, Professor K. Das was the mother vice chancellor. When, my lord, I was confirmed in 2022, that vice chancellor was not there. It says, my lord, next vice chancellor. Therefore, my lord, if there was any bias on the part of the, my lord, the vice chancellor who was there at the time of my selection, that would not have been there when a new vice chancellor was there. And my lord, the appointment of the petitioner, the entire process of selection that was conducted, this registrar who has signed the, my lord, notice, he was also present, my lord. In the, my lord, recommendation also, he was consideration, he was there. In the selection committee, he was there when I was, my lord, considered. My academic credentials was considered. And when the, my lord, appointment was decided, my lord, he was there. And my lord, he was a party to the selection committee who selected the petition. Now, all on a sudden, my lord, you come and say that the procedure adopted was not proper. If your lordship kindly comes to page 104, the lordship will find that, my lord, that is a communication dated 19/9/2022 that was issued by the university and addressed to the government, Additional Secretary, Government of Assam. There your lordship will find, my lord. May I read that? Page 104. This is a communication from the university to the government regarding, my lord, some communications they issued pertaining to me. With reference to the subject and references cited above, I am directed to furnish the following information regarding the appointment of Sri Jayanta Kumar Sharma as professor in Dr. Bhupen Hazarika School of Mass Communication. A letter wide number such and such dated 5/2/2022 was received from Deputy Secretary to Governor Assam, forwarding a copy of the petition dated 7/1/2022 regarding gross anomalies in selection and appointment of Sri Jayanta Kumar Sharma as professor. My lord, that document, that, my lord, political outfit which has submitted that document, my lord, wherein it was requested to examine and furnish a report on the matter to the Honorable Chancellor. As such, a report was sent by letter number such and such. The Board of Management on its 67 meeting was apprised of the above communication received from the office of the Honorable Chancellor in connection with the petition submitted by the to the Chancellor regarding appointment of Sri Jayanta Kumar Sharma. Sri Jayanta Kumar Sharma has furnished the following particulars among others in the application. Number of publication, 1, research guidance, then, my lord, work experience, PhD, so and so, my lord, other particulars have been given. Then paragraph 4, next page. Further, another communication was received from the Secretary to the Government, Governor of Assam, requesting to furnish a copy of the biodata along with the application form submitted by the other candidates, namely Dr. Dipendra Kumar Majumdar for the post of professor. The reply was sent such and such. This above submission is made on the examination of the particulars regarding appointment of Sri Jayanta Kumar Sharma for onward submission to the Honorable Chancellor, who will provide any further information that you may seek for regarding the same. Now, my lord, by this communication, that is in, my lord, 19/9/2022, they have in fact, my lord, defended my appointment. They have not said anything against me. Now, my lord, my submissions before your lordship, my lord, your lordship has gone through the facts. I perhaps need not take your lordship's time to refer to my biodata, my lord, to show that, my lord, I fulfill the conditions made in B. Those are there, my lord. Now, my first submission is that, my lord, I was appointed during the time of a vice chancellor. He was not there when, my lord, my service was confirmed after, my lord, the probationary period. Then secondly, my lord, my suitability and eligibility are two different things, my lord. Suitability is, my lord, is objective, and my lord, the my lord, suitability is subjective, whereas, my lord, the eligibility is objective. Now, by this process, they want to adopt, my lord, they want to sit over three things. They want to sit over the recommendation made by the two experts, which says that I am eligible to be considered, based on which I was called for the interview. This is one, my lord, they want to supersede. Secondly, my lord, the selection process they held as per UGC regulation, where, my lord, I have been found suitable, they want to supersede this. And thirdly, my lord, the confirmation of service, that also, my lord, they want to supersede. Now, on the strength of the order of the Honorable Division Bench, my lord, they want to give a complete go-by to the procedure, and, my lord, they want that the committee should decide my fate, which will eventually be placed before the Board of Management, where the same members will be there. And this is their design, my lord. That is what they wanted to do all through, my lord. Because of the interference of this Honorable Court, my lord, I am still in service. Therefore, the moot question is, my lord, whether the suitability or even eligibility of the petitioner can be judged by a committee after the, my lord, all the procedures have been followed in the, my lord, selection process, and, my lord, after confirmation. Allowing that will mean that I have my eligibility and even my suitability will be considered by a committee which is comprised of Board of Management members, and, my lord, the committee report will be placed before the Board of my lord, the members, and that will be, my lord, as if the Board of Management is the judge, jury, and the executor. So this is the extent the university is trying to go, just to, my lord, get my services dispensed with. But by the same procedure, three more professors were selected and appointed. No question has been raised regarding the procedure. Because, my lord, in the cases of, my lord, the advertisement, your lordship, I have pointed out that the other posts of professors were advertised. The same procedure was followed, where, my lord, their eligibility conditions were thought to be, my lord, sent for assessment by two experts, outside experts. On the basis of that recommendation, my lord, the interview took place. Thereafter, my lord, they were the selected persons were appointed. No question has been raised on those persons. I have been chosen for, my lord, this treatment because, my lord, there is a complaint from a political outfit. And, my lord, they also, my learned friend also referred to from the communications, my lord, Dr. Srinath Barua, who was the earlier, my lord, vice chancellor, he wrote a report. One complaint was, my lord, raised on his behalf, and subsequently he said that, my lord, I have not given any complaint against him. So, my lord, one circle is working, which is, my lord, manipulating documents, and that thereafter, my lord, it has been sent to the chancellor. Chancellor says, okay, you inquire. This is first is, my lord. Now, this is, my lord, a letter addressed to the governor, this chancellor, where, my lord, it has been stated, your lordship may skip, my lord, the first part because the complaints have been, my lord, mentioned. Last sentence, your lordship will see. In reference to the above mentioned UGC eligibility conditions for applying the post of professor, I'd like to draw your kind attention to the following facts. Number one, Dr. Jayanta Kumar Sharma had not submitted minimum 10 research publications in the peer review of UGC. This is not required, my lord. This requirement is as far as my lord the clause A is concerned, not clause B. I fulfill clause B. So this has been my lord given. Then Jayanta Kumar Sharma had not submitted any daily teacher's experience. This is also my lord not required because my lord I fulfill the condition in requirement B, my lord. Jayanta Kumar Sharma had not submitted any evidence of having successfully guided doctorate degree. That is not required, my lord. Therefore, my lord, what is the requirement of clause B? That is very important. Under the aforesaid context, it was really surprising how did Jayanta Kumar Sharma get selected for the post of professor and have been continuing as professor in mass communication. It is evident from the information received from the university under RTI Act that many times many parties had bring many matter to your knowledge and the university administration has already submitted all documents, Dr. Jayanta Kumar, but we have not seen any concrete action neither from your end for the nor from the university authority. If people like Dr. Jayanta Kumar Sharma could become professor in such illegal way in a broad daylight and continue his service in the university, we are afraid, sir, no UGC regulation can be maintained standard of higher education in India. Being in the highest constitutional post, the state being at a different prefer person. Later, huh? So, this complaint is shown to be given by Professor Sunal Borua, Professor S. Borua. As if, my lord, he has lodged the complaint to the, my lord, to the, my lord, governor. And, my lord, when Dr. Srinath Borua came to know of this, my lord, your lordship will kindly see his letter. March 11, my lord, I have given the copy. There is a caucus in the university, my lord, who is trying to manipulate records and misrepresent to the governor. Dr. Borua wrote to the, my lord, Chancellor Governor, Your Excellency, I request, has your lordship got this paper, my lord? I request you to kindly permit me to place before you the following clarification in connection with a letter dated nil addressed to Your Excellency by a person named Professor S. Borua, a resident of Chanmari Housing Colony, Guwahati 3, regarding the irregularities in the appointment of Dr. Jayanta Kumar Sharma as Professor of Mass Communication in the School of Bhupen Hazarika Mass Communication. I understand that an impression is created among the faculty, staff, and administration in the KKHSAU that the complaint against Dr. Jayanta Kumar Sharma was made by me in the background. He was the Vice Chancellor earlier, my lord. Number one, that I wrote a number of letters to Your Excellency during 2017 to 21 on irregularities in the construction of city campus of the university during the tenure of Dr. Hitesh Deka. Number two, that the short signature in the complaint letter by Professor S. Borua resembles my short signature, which I occasionally made in the office files during my tenure as founder, Vice Chancellor of KKSOU. I would like to clarify that I never wrote the said letter or any other letter to Your Excellency on the matter of appointment of Dr. Jayanta Kumar. I made a personal inquiry about the existence of so-called Professor S. Borua in Housing Colony, Sanmari, Guwahati, and I got the impression that there was no resident by the name of Professor S. Borua in Sanmari Colony. I believe that only the district administration can locate the said Professor S. Borua Sanmari Colony to ascertain whether the said complaints is fake or not. So, my lord, fake complaints has been sent to the governor. Subsequently, also, my lord, there are other communications points or more manipulated communication. Now, my lord, if your lordship এখন দিছা নেকি? Now, my lord, this is a communication from the registrar of the, my lord, KK Hendick University, where, my lord, a para 3 and 4, it has been stated clearly that as per the record, may I supply a copy, my lord? In fact, my lord, the hearing earlier, my lord, was conducted in a such a hurried manner. We could not bring this by an affidavit, my lord. So we placed before the court. This communication by the registrar to the, my lord, Deputy Secretary to Governor of Assam. That is, my lord, to the Chancellor. In inviting a reference to the subject cited above, I am directed to inform that the Joint Kumar Sharma was appointed as professor. Then para 2, the para-wise information provided by the university to petitioner on the RTI indicate that the process followed by the university in terms of advertisement release for the post, collection of candidates particulars through a standard form, formation of selection committee, preparing interview score sheet, submission of selection committee proceeding to board of management are taking resolution before the issuing appointment letter. And para 3, my lord, as per record available in the office of the registrar, the selection committee considered the suitability of the candidate in terms of the requirement and performance in the interview. Based on the recommendation and subsequent approval of the BOM, the offer of appointment was made. Dr. Jayanta Kumar Sharma joined the university as professor on 1/2/2021, and his service was confirmed after successful completion. My lord, there is no whisper regarding my lord, the allegation. So, my lord, they are defending my appointment, the same registrar. Now, my lord, he takes a different stand, although he was a part of the, my lord, entire selection process. Therefore, my lord, my submission is that, my lord, allowing the committee to make reassessment will amount to, my lord, revisiting the entire, my lord, exercise that was carried out as per the statute of the university, as per the UGC regulation. This cannot be permitted. The committee and the board of management cannot be allowed to be, my lord, the prosecutor and executor and judge. So far as my eligibility is concerned, my lord, page 104 is very clear, my lord. From that, my lord, my eligibility has been, my lord, indicated. That's a communication of the, my lord, the university to the governor. Therefore, my lord, the issue for determination before your lordship is that, my lord, whether the petitioner can be subjected to a, my lord, process of assessment of his eligibility conditions after, my lord, all this has happened. This is my condition.
My lord, we'll submit our part day after tomorrow.
Part, sir, part, part, eh,
1 to 4.
part in part, day after further hearing.
Most probably.
My lord, I'm grateful for giving a, my lord, patient hearing. I reserve my right to reply, my lord, after taking. All right.
Most probably.
Please look, but can it be after some time? ABT होगी लेक सेट for number 16.
Okay.
May I please, your lordship? Lordship, as per the office note to 28, run 25, Reminder for requisition of SCN copy of TCR has not been in this case was
Yes,
SCN not
service
received.
report available.
In that loss, I have contacted the officer concerned. He is about to give me the
Report.
report.
Let's select the matter day after tomorrow. Day after
On Friday.
the matter, sir. Doctor learned additional fees for the service report. Register also issue reminder, urgent reminder to the learned record for transmitting the record for
Obliged. Made this, your lordship. This is second bail application, my lord, under NDPS Act. My lord, there are 5 accused, my lord. 3 has already been released. 2 has been released by your lordship, my lord, and the other one is by the session judge. My lord,
So what is the ground for filing the second application?
my lord, the ground of arrest was not furnished. My lord, I am annexed the notice, my lord, annexure 6 and 7.
Is number
Annexure 6, page 48, my lord.
8. So for any doubt regarding non-furnishing of ground to the accused person at the time of
The ground of arrest has been furnished, but it is as usual, lordship, not the entire the elaborate ground of arrest why everything is not mentioned. But
so in the notice, where is the ground?
that I have flagged my lordship that sections are there, lordship, that against that sections you have been arrested. That is there, lordship.
No, whether mere mention of the sections are sufficient.
So recently, one new judgment has come, lordship. That is state of Karnataka versus Sri Darshan itself, ATC. Here in this case, and the entire issue has been discussed again, lordship, regarding ground of arrest, lordship. That Bihan Kumar judgment, Pravir Burkas, Pankaj Bansal, everything has been decided. In para 20.1.
Paragraph number
20.1, lordship. That flag mark is there.
20.1.
Lordship, the entire from 20.1.1 to 1.7, lordship. If lordship permits, I can read out.
Which is the relevant paragraph?
Lordship, relevant paragraph is 21.7, last paragraph. In the present case, the arrest memos and remand records clearly reflects that the respondents were aware of the reasons for their arrest. They were legally represented from the outset and applied for bail shortly after arrest, evidencing an immediate and informed understanding of the accusations. No material has been placed on records to establish that any prejudice was caused due to alleged procedural lapse. In the absence of demonstrable prejudice, such as irregularity is at best a curable defect and cannot by itself warrant a release on bail. As reiterated above, the High Court treated it as a determinative factor while overlooking the gravity of the search under Section 302 IPC and the existence of a prima facie case. Its reliance on Pankaj Bansal and Pravir Purkastra is misplaced, as those decisions turned on materially different facts and statutory context. The approach adopted here is inconsistent with the settled principles that procedural lapse in furnishing grounds of arrest absence prejudice do not ipso facto render custody illegal or entitle the accused to bail.
Prior to that, Lordship, from 1.2.121.2, it has been elaborately discussed, Lordship, why this opinion has come, Lordship. 21.2. Article 22.1 of the Constitution mandates that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Similarly, Section 51 CRPC requires that every police officer or other person arrested any person without warrant shall forthwith communicate to him full particulars of the offence for which he is arrested or other grounds for such arrest. 3. The constitutional and statutory framework thus mandates that the arrested person must be informed uh, of the ground of arrest, but neither provisions prescribe a specific form or insist upon written communication in every case. Judicial precedents have clarified that substantial compliance with these requirements is sufficient unless demonstrable prejudice is shown. 4. The Bihan Kumar versus State of Haryana, it was reiterated that Article 22.1 is satisfied if the accused is made aware of the arrest grounds in substance, even if not conveyed in writing. Similarly, in Kasireddy Upendra Reddy versus State of Andhra Pradesh, it was observed that when arrest is made pursuant to a warrant, reading out the warrant amounts to sufficient compliance.
That decision will not help you with the state of Andhra Pradesh because here he has not been arrested on the basis of warrant of arrest.
Lordship. This is the
The question is whether
state of Karnataka is not
mentioned in the notice official.
and that is has been later part, Lordship, that has been discussed, Lordship. Why it is not if it is not elaborately even though it is not mentioned the entire the specific and individual grounds, even though that has also been discussed, Lordship.
No, you see what ground you have mentioned in the notice under section 50 of the CRPC.
Lordship, that is, Lordship, that when person is caught red-handed, Lordship, and when there is when the Article 22.1 never says, Lordship, that Lordship, it has to be in writing form, written form. The reason for Article 22.1 is, Lordship, for to know why he has been arrested, and so that the second part comes, Lordship, when so that he can engage one counsel for release him as soon as possible of his choice. The second part. So here in this case, Lordship, here it has been discussed, Lordship, that if the second part is complied and there is no demonstrably he is prejudiced. Demonstrable prejudice to what I have understood, Lordship, that Lordship, when person is caught red-handed, he has been given the section 50 notice, Lordship, and what we have now at present, Lordship, along with this case, Lordship, and subsequently when as soon as shortly he has been engaged, he engaged some advocate, some counsel to release his bail, release him. That it amounts to that he has been aware about the ground of arrest.
Whether it is present in the present case, the accused has engaged his counsel for filing his bail application.
Lordship, that I could not go to enter LCA, Lordship. I tried to
Mr. Day,
My lord.
do one thing, if please go through this judgment.
My
There,
Your lordship has many a times seen the Supreme Court judgment very categorical, and this
no, that's
Karnataka.
right, but this subsequent decision is quite different from the other decision. Therefore, you please go through the same and you come prepared on day after tomorrow. In the meantime,
on Friday, Lordship, day after tomorrow, sir, I have some on
when?
Friday.
Friday.
On Friday.
Friday. Hard, sir. Vacated or not? Like, sir,
Nothing big.
run the stock out.
Little
Hard,
bit.
Sit the hard part. It's the method. Friday. And in the meantime, the day learned on the to the relied upon by her offer. State of Karnataka versus Johnson, etc. see online as 170. Specific paragraph number 20.1.
But Lordship, in the meantime, Lordship, for confirming that part, Lordship, whether he has engaged some and for that LCR has to be in complete, Lordship. But those part never comes sent along with that LCR, Lordship. Regarding his engagement of advocates, petitions, those are not comes. Those never comes along with that. Some orders, it may be reflect, Lordship, in some part in order column.
You go through the record. Yes, so far it's
Yes, my lord. Regarding contempt case, my lord, it is under process, my lord.
it's a
Yes.
art art learn. The portal gate Norma has 40 dated 26 8 2025 with deputy secretary the government at the same time of average that arrear salary proposal for an amount of 6 lakh of 400 is received from the director secretary and the same under and on the appropriate letter Mr. Norma has tried for granting and comply with the order of court. There is extension of this after 1 week
2 weeks, my lord.
and
That's because financial.
after 10 days. Letter for the that mark as A part of in WPC.
Lordship, in item number 21, Lordship, a proposal has already been sent by the headmaster to the inspector of school, Dhobri, Lord. Today,
Proposal has been forwarded
today only,
today
Lord.
To the inspector of school.
Lord.
Norma, how much time will it take?
10 days, my lord. 10 days or 2 weeks.
Or or it's not learned. Not learned. That the headmaster of that concern is forwarded the proposal of the of the inspector Dhuri.
Dhobri.
So Norma learned. No. Okay, up to date inspector. Up to the proposal by the inspector. Only the inspector will only forward the thing to the government.
Yes,
The
director,
government
director,
ultimately
director, yes.
obtain update of the proposal being sent by the headmaster of the school, the office director,
Director of secondary division.
secondary or higher,
No, secondary.
secondary. It's a matter of 10 days.
My lord, regarding the item 24, my lord.
Date
Here,
can
my,
kindly be fixed.
Take it in front.
regarding the, my lord, item 24. My lord, the case of the petitioner has placed before the personnel department, my lord. And because no, and because for the personnel department is also there on 6/6/2025.
No, is it a big process?
Yes, yes, it is possible.
Okay, on negative average.
Yes, yes.
That
Lord. During based upon response number 7, service is not complete, Lord.
service completed.
Not completed upon response number 7. Others are completed.
Respondent number 7.
May allow us to also serve the state through the principal of the college because the person is still also serving the state college, but he has not received the notice. So we can also serve through the principal of the college.
No, whether he is serving in the
Yes, sir.
college
As per my instruction from my client, also yesterday he is working in the state college.
or Mr. Bobita learning. Mr. Bobita submits that he granted site effect service of the respondent number 7 to the principal of the college.
On principal of the college.
Principal of
That is response number 5. Through response number 5.
the respondent number 5. There is accordingly allowed the be taken within 4 days from today. This is the matter after 2 weeks.
2 weeks, Lord. There is an interim order also taken.
Interim order plus ordinance.
Lord. Obliged.
May regular. Yes, service in all the respondents is completed except respondent number 10. We need to take fresh step and respondent number 10.
Art means
R. Shah.
Sir,
P. Hazarika on behalf of SR Rafa.
P. Hazarika, Current Concept, behalf of Sir,
Rafa.
Current respondent number
2, 4, and 5.
4 and 5 and Sir,
Respondent 6 to 13 except 10.
respondent number 6.
6 to 13 except 10.
6, 13,
Except 10.
except 10. Ms. Saha learned concept for the petitioner subset. She may be permitted to take fresh step upon respondent number 10.
10.
There is accordingly allowed the taken by registered from additionally, justice service also permit. This is the matter after. For it,
That is the Tata Institute of Social Science matter, where
yeah.
the petitioner appeared, there was no advertisement post seats, and my learned senior friend appears for the Tata Institute of Social Science. My case was that, while the issuing them a notice, page 21, 2 seats were shown to be vacant, for general category candidates, but there was no reservation shown. Page 22, in peace and conflict studies, Master of Arts, peace and conflict studies. Page 22, 2 vacancies were 2 seats were shown, and for Northeast, there is separate, reservation, 14 seats. I'm not on that, My case was, that there are 2 seats available which were not shown to be reserved, and I was one of the 2 candidates. And thereafter, by a mail, later on I was informed, that there are no, general seats available. Page 26, madam. Since, I was not, I had not received any mail, and I was told, if I don't receive any mail, I should presume that I was not selected. Accordingly, page 26, after I had sent the mail, they had sent one mail, Lordship will see, page 26. Dear candidate, it's, about 7-8 lines to the top, Dear candidate,
Reservation rules are also applicable for spot round also. I had applied for a spot round, my lord, and there are no general seats available. My lord, therefore, I am before lordship, my lord. My case is that, my lord, since
Whether this notice is a complete notice. You have enrolled that.
that is what I was given, my lord, the mail, my lord. That is what I was given them. This is only for the spot admission only. My lord, they have, my lord, three, my lord, generally, my lord, three selection process, my lord. One is a CUET, my lord. Then, my lord, after that spot admission, and then there is another round of interview that is scheduled, my lord. There is non-CUET on 23rd, my lord. That also I have a next, my lord. So in this, the mail which was sent.
Doctor, you tell me whether this page number 22 is a complete advertisement.
That is the mail that I received, my lord. Because, my lord, this spot notification was informed, my lord. Lordship will see page 21. Dear candidate, please find below the link to check the seats available. So, my lord, this is the seats available, details for spot admission and Zoom links details. So accordingly, my lord, this is what I could download, my lord, from the, my lord, website, my lord, 22. Two posts, my lord, two seats, my lord, for there is no reservation shown, my lord. But in Northeast, for Northeast vacancy, my lord, they have specifically shown reservation, my lord. So therefore, my lord, I feel, my lord, this where, my lord, there is no reservation, my lord, was shown, my lord. So therefore, I appeared for this seat, my lord.
Where it is stated for Northeast reservation.
My lord, next column, my lord.
Right?
Next, my lord, column, page 22, my lord. Lordship will see, my lord,
Reservation.
Yes, Northeast reservation vacant, my lord. Guwahati campus, my lord. I'm concerned with Guwahati campus, my lord. I have applied for the All India seats, my lord. Second one, Master of Arts in Peace and Communication Studies, 2 seats, my lord. There is no vacuum, my lord, no reservation mentioned.
Maybe, but on the top of the column, it is mentioned that Northeast reservation.
No, Northeast reservation 14 seats, other next column, my lord. That is a different, my lord. 2 seats for general, my lord. Northeast reservation 14 seats. I am not concerned with that, my lord. That I am not, my lord, contesting, my lord. For Northeast region, my lord, since my lord, TISS, my lord, has to, my lord, have, my lord,
Are you not belonging to Northeast?
No, I am from, my lord, Orissa, my lord. I am competing for the All India seat, my lord. I am not from Northeast, my lord. I am competing for, my lord, that's why I'm, my lord, on the All India seats, my lord. 2 seats only. These 14 seats are out of my, lord. That's not within my, lord. I have not applied for that, my lord. I had applied for 2 seats only, my lord. And my case is there are only 2 candidates were there. Because, my lord, it was a, my lord, spot admission. So I was sitting in the, my lord, process, my lord, because it was through, my lord, online, my lord, Zoom link, my lord. I was sitting, my lord, and my name is, it starts with S. So, my lord, it's almost at the bottom, like N, my lord, the list, my lord, serially, alphabetically. So, different candidates have appeared for different, my lord, courses, my lord. And to my, my lord, information, my lord, two candidates, my lord, me and another candidate appeared for, my lord, this peace and conflict studies.
I appear for Tata Institute of Social Science. Now, there are a lot of things which my learned friend client has not projected before the court. This is what yesterday they came to my place and they have instructed me what is about the case, and it has not been projected correctly before the court. Now, he has annexed, his client has annexed one. There are, like, my lord, there are a lot of programs in Tata Institute of Science. Where is all India level university can also participate. Tata Institute is also one of the where their students can participate. These are Master of Arts program. Now, there are out of 25 programs, maximum 3 you can participate in a program, a student in respect of Tata Institute of Science. Now, he has only annexed one program. There are 3 programs which he have participated. Now, I'll tell what are the 3 programs. I'll bring it in affidavit. But for your lordship should know what is the real picture in this case. He doesn't have a legal right.
Then you bring out the instruction by filing an affidavit.
Yes, yes.
That will be better.
Yes, no, I will wait. No, I'll tell you, your lordship, I'll tell you what is the case. 3 courses he applied, program. Now, on the 3, 2 in Mumbai, where he belongs to Orissa. He applied 2 in Mumbai and 1 at Guwahati campus. Now, 3 subjects where he applied. One was regarding Master of Arts in Social Work Counseling in Guwahati, where he applied. Now, another Master of Arts in Applied Psychological, Clinical and Counseling Practice, Mumbai. Another Mumbai, he applied is Master of Art in Social Work, Mental Health. So these are 3 programs which he applied.
When he applied, he did not qualify all on fees because it is based on the marks. So he was not within the cutoff mark. Now there were some seats available in Guwahati. So by a mail, it was sent general to all the students who did not got all these three, and there are other students. Now an email was sent to him on 1st of August that there is a Zoom link in respect of which are the particular spot admission in respect of the courses. On it will be on 2nd. So first it was sent, second to appear, second he did not appear. This candidate did not appear for the counseling. Now even for what, my lord? For the subject Master of Art in Social Work Counseling, because that he applied in Guwahati, which he did not get a cut-off mark. Now we have given an option because there are seats available. Now in the first meeting on Zoom on 1st, we notified him that there are seats available. Even you did not qualify, there are seats available. You be on the Zoom on 2nd. He did not appear on 2nd. It is on record. Now again we have given a chance on 6th by a mail saying that 7th there is a counseling, there is a particular Zoom. You please be present. Now in that, what the course he applied, he doesn't want that course. He wants a course which he has not applied for. He did not apply for that course. Now, when it was in a Zoom, it was asked, he said, so far as Master of Arts in Peace and Conflict Studies, there are 2 seats available. We said, yes, available. But you are not entitled to get because you applied in different program. How you are entitled to get it? Now, he said there are 2 posts which is meant. Yes, there are 2 posts which is reserved category. This you are not entitled to get it because you did not apply. You have to apply. You did not apply. Now, these 2 seats, which my learned friend has said that there are 2 seats which reservation, it is belong to reserve category. Now, in that also, my lord, that has been filled up. This is my instruction. I will bring it in affidavit. Now, this is the my lord case. Now, they would have 34% is reserved for all India. 66% is reserved for Northeast, including the Sikkim. That's what the regulation, my lord, donor regulation, they have laid down, Government of India. Benefit is given because of Northeast. 34% also a roster is being maintained. Now this time they have not mentioned specifically that it is for reserve category, these 2 seats are available. But even then, throughout we are maintaining the reservation policy. Roster has been maintained. Now this time they may not have mentioned. But that's a different aspect altogether. But only, my lord, I am just putting it before across your lordship. But this particular program, he has not applied. So one, if he has not applied, whether he is entitled to get to even ask before us that 2 seats are available because you have not applied for that. You applied for Master of Arts in Social Work Counseling. On 1st, you have been notified. On 2nd, you did not appear before Zoom link. Even the authority said, okay, 6, there is another 7, there is a counseling, please appear. In that, he appeared and he asked for a seat which is did not apply. That's the case, my lord. We want to place it by way of an affidavit. Give us a time because now the seats are also being filled up. Now your lordship will decide whether once you apply and whether you can ask for a different. Because I am not saying it is by way of a prospectus. I have said that please tell me whether it is by way of brochure, prospectus, whether it is indicated, and everything is indicated here. Suppose a student, maximum 3, you apply for a particular subject. In that subject, only you can ask for that seat if it is available. And that is why in Guwahati, there are few seats which was available. But which now the question is whether he has missed the bus on the 1st itself. He was asked because on 2nd, I think my learned friend client has not been projected. But my rejection, which has been communicated to him, because he said regarding about the subject, which is Master of Arts in Peace and Conflict Studies, yes, there were 2 seats which was vacant, and that is belong to reserve category. That we have an answer and we have rejected. But the case is that He is not entitled even to get that particular seat because he did not apply. That's the case, my lord. I'll bring it by way of an affidavit. My lord, a student career is involved. So I told them that if something can be done, we also understand it is a matter of his career. But sometimes it happens that it, it becomes a precedent that floodgate will be open. So how they can do it?
If it is possible to settle the matter outside the
No,
court,
I will,
then
I will try.
the question of
But
precedent will not-
my lord, what is let me bring with an affidavit before this court. Give us a 2 weeks time. I am not asking more because now this he's particular.
Right, I will give you time.
Yes.
But if possible,
No, I will try. I'll try to communicate to them with that, my lord. But it's up to them. I'll try to convince, but it's up to them. But let me bring all this by an affidavit. All this, whatever I said for this court, with an affidavit, copy, advance copy will be served.
This court is not interested so much in your affidavit. I am interested in getting a seat from him for him.
That is, if possible, my
If
lord.
possible, yes, within the parameter.
My lord, that is what I said, my lord. I told them that is a student is involved, career is involved. So why don't they will have a discussion with the people higher ups in Mumbai. There is a people who is sitting there in Mumbai. So they will decide. This should not be a precedent. Like that's it, that is a precedent. That is why.
Instead of filing the affidavit, if you manage the seat for him, that's all right.
No, my lord, the problem is that let me file an affidavit. Let me, your lordship, in the meantime, let me have a discussion with, already it was informed. Let me see whether what communication they have sent, but your lordship will kindly give a direction so that we can file an affidavit for the court. Yes.
Only prayer, my lord, since it's an admission matter, my lord, can be a little shorter time, my lord. Because, my lord,
2 weeks, I think 2 weeks is a very reasonable time.
Otherwise, my lord,
I could have asked for 4 weeks. I know that his
understand
career is involved. That is why I've said 2 weeks. Because once it is prepared, it goes before Mumbai, settled and it's sent. So 2 weeks is very reasonable, I'm asking that.
The only
If
part
it is not
whether-
inconvenient or
whether I can be considered because my lord, what my learned senior friend is submitting, my lord, of course, my lord, he has the my lord, but what my lord, my instruction is, my lord, he applied for master in social work. I'm not denying and next that, my lord. But subsequently he also applied for this particular seat, my lord. And since it was not shown to be reserved, he was on the option, my lord, under the my lord, impression, my lord, since it's not because the advertisement must show that it is reserved.
My lord, that
is
is
where
a
the
different. If my learned friend can show that really he's applied for Master of Arts in Peace and Conflict, let him show before the court, I've applied and I have not been considered. He have to show prima facie or not by saying a mail. That means because Zoom, when it is a Zoom, it is not in respect of his subject, in respect of all the subject, in respect of all the candidates.
Because
That is.
my lord, my
And
my lord,
first round, I don't know why in the first round, why he has missed that. I have got a mail which has been sent on first and second there is a Zoom meeting, but never appeared. Even in our authority, they know is a career of student. Even it was informed to him on 6 to appear on 7. 7, this is a problem which has occurred.
because my lord, after my lord appearing, my lord, I sent this mail, my lord. It's my lord, online process, my lord.
No, I will show it.
It's an
That's
online
why,
process.
that's why let an
Yes,
affidavit.
on, my lord, on 11th, my lord, that's
Yes.
8th, I wrote this specific mail.
He does,
It's R. Sharma, yes.
counsel for the that yes, and that's the thing. I we have been affidavit and price type.
Oh, 10 September.
My lord,
10 September.
my lord, can you be some other date, my lord? My lord, other than 10th, my lord. Before that, it is possible. 10th, my lord. Can it be on 12th, my lord?
12th is Saturday. No, sorry, it's a holiday.
12th.
My learned friend has to come alone. My learned friend has to come.
I'm sorry, my lord. Then 15th, my lord. 15th.
15, okay.
15th.
ठीक है, ठीक है. I'm deeply obliged.
Deeply
Your Lordship. Lordship, this matter may be, I mean, forwarded to Lok Adalat
one last chance may be given for amicable settlement. Otherwise, lordship hearing may be conducted.
Yes, Mr. Khan.
First, I have no objection.
Okay.
On last occasion, Lordship has pointed out one thing, whether any judgment can be pointed out regarding Lordship the starting point of limitation regarding date of death. That matter, Lordship, a person was not found, driver was not found, and FIR has been filed.
Okay, okay.
For that case. I have put the judgment also. That may be referred to the local adalat. I am not against the claimant Lordship. I am on the law point.
So when the next date is for Kolkata?
13 September. 13 September.
Third message with Kolkata. Then third at the Mr. Das that the matter may be referred to the Kolkata. We have done 30 September. Including taking official on this matter is not referred to the Kolkata. So we have done 30 of September. By some accord.
Oblige, Lordship. Highly oblige.
It's the perfect. Yes, Mr. Goya.
My lord, an affidavit has been filed by the Sarva Shiksha Vision Mission, my lord. My lord, from the affidavit, my lord, I've gone through. Nothing is clear, my lord, regarding that, whether I am in service, whether I have been terminated, whether a proper disciplinary proceeding had been initiated against me or not. It is not very clear and distinct from the affidavit, my lord. My lord, what has happened in my case? My lord, while I was working as a my lord, district program officer in a contractual manner under the Sarva Shiksha Abhijan Mission, my lord, then, my lord, an allegation of corruption that I have demanded an amount of rupees 10,000 from a teacher, my lord, for some official works, my lord. And basing on that allegation, my lord, a trap had also been initiated and I was arrested and was also behind the bar for 13 days. Later on, my lord, I have come out on bail. Now, my lord, when I have come out, as there is no any suspension, no any termination, nothing was there. Then, my lord, I approached before the authority that I should be allowed to continue in my service. That's because, my lord, there is no any black and white order till date. My lord, had not been issued. Neither I have been placed under suspension, my lord, nor any, my lord, order terminating me from my service had been served on me. Now, my lord, in such a situation, my lord, when I approached before my lordships, my lord, that the approach which I had made before the authority to, my lord, allow me to continue, that approach and prayer has also not been accepted, my lord. So therefore, my lord, and two affidavit has been filed by the, my lord, Sarva Shiksha Abhijan Mission. They have now in the last affidavit, my lord, which they have filed, my lord, a stand had been taken that, my lord, as my contract agreement, my lord, which is already has been expired. So, my lord, therefore, I am no more in service. That type of statement had I have seen in the affidavit, my lord, also. If my lord may be pleased to take up the affidavit which they have filed, my lord, in paragraph 121 in page.
Yes.
Lord, I am in the bold manner, my lord, they have said, may I read, my lord? Even assuming that his service contract agreement deemed to have been extended, as he was allowed to draw his salary oblique remuneration, even in this situation, such deemed extension of contract cannot be treated as still subsisting as the competent authority in the SSA had taken a decision to stop his monthly salary from 16/9/2022 by letter number dated 16/9/2022. Therefore, in view of the above explained facts and circumstances, it is in view of the SSA authority that once the contractual service of the petitioner cease to exist, there is no requirement for the authority to take a decision as to what penalty is to be imposed against the petitioner pursuant to the proceeding initiated against him. In this regard, it is also to be taken note of the fact that after submission of the inquiry report, the petitioner was granted an opportunity to represent his side, which opportunity the petitioner preferred not to utilize. Accordingly, it is humbly submit that there is no other conclusion which can be drawn other than the conclusion that the status of the proceeding initiated against the petitioner by issuing the so-called notice dated 16/9/2022 is completed. So, my lord, only an order which, my lord, the department has annexed is an order of, my lord, 16/9/2022, annexure 2 in Roman 2, my lord, whereby my salary had been shown to be, my lord, stopped. If my lord may be pleased to find that, my lord, in 9/20. No, affidavit তো দিয়া নাই। My lord can, I beg to draw, my lord, my lordship's attention, my lord, is a page that annexure 2 dated 16/9/22 is an part of my writ petition, my lord, is at page 67, my lord. This is, my lord, regarding arrest of Sri Azaharul Islam, District Program Officer, STSSA Dhubri. In enclosing herewith a copy of the so-called notice, you are hereby requested to serve the so-called notice to Azaharul Islam, District Program Officer Dhubri, and acknowledge the receipt of the same. Further, the monthly salary of Azaharul Islam, District Program Officer STSSA Dhubri should be stopped. So, my lord, therefore, from 16/9/2022, my salary had been stopped, but, my lord, there is no order as such regarding, my lord, my termination or any decision they have taken as regards, my lord, the disciplinary proceeding which they have initiated. My lord may be pleased to find the disciplinary proceeding, my lord, culminated last on at page 78, annexure 18, my lord. My lord, may kindly at page 78, my lord. This is a letter issued to me, my lord, the petitioner, on 11/10/2022. With reference to the above, you are requested to attend a hearing on 11/10/2022 at 11 a.m. in the State Mission Office, SSA, Assam, Kahilipara, Guwahati, 19, in connection with arrest. This is for your information and necessary action. So, my lord, thereafter, my lord, when I approached the, my lord, on hearing, and I have presented my case also as per my instruction, my lord, but nothing has been done thereafter, my lord. And then I made the specific subsequent representation after representations, my lord. The last representation which I have made is at page 84, my lord, of my writ petition on 16/2/2023, my lord, to with a request to allow me to resume my duties in the respective post as the district program officer, Dhubri, Assam. My lord, this representation are still pending, my lord, as per my instruction, my lord. Till date, they have not taken any decision as regard passing any speaking order or releasing or saying that my contract agreement has already been expired, so therefore you are no more in service. Now, my lord, even I assume, my lord, in such type of situations, my lordship is well aware that the termination is simpliciter and stigmatic, my lord. Here is a case, my lord, whereas an allegation has been already leveled against me that I have committed some corruption under the Prevention and Corruption case is already pending in a milord before the authority. Now, milord, if in such a manner, milord, they have said goodbye to me from my service and job, milord, it will be very, milord, not only stigmatic, it will be detrimental to my future service prospect also, milord. So therefore, a proper inquiry, a proper disciplinary proceeding, milord, by furnishing with me a charge memo along with a list of documents, milord, list of witnesses for the proper principle of natural justice ought to have complied with, milord. My lordship also knows, milord, there are series of judgments in milord in this type of situation wherein the honorable apex court has categorically reiterated that, milord, that the principle of natural justice should be followed in total compliance, my lord. Now, my lord, here is a case. If my lordship, they have said by of a letter wherein they have said that the Assam Services discipline and appeal rules is applicable for these categories of employees also, my lord. And for that, my lord, I beg to draw my lordship's attention, my lord, to page 44 of my writ petition, my lord.
Yes.
My lord, in this is a letter, my lord, and the date is of 14/8/2015. Save is otherwise expressly provided in service regulation and the financial rules of 2003 for of Assam Sarva Shiksha Abhijan Mission. It is hereby notified that the spirit of the rules and procedure as prescribed under the Assam Services Discipline and Appeal Rules 1964, followed by the Government of Assam for inquiry, departmental proceeding, award of punishment, appeals, etc. shall be allowed by so and so as and when any inquiry or the departmental proceedings are required to be conducted in respect of an employee, contractual or otherwise, employed under the Assam Sarva Shiksha Abhijan Mission. So, my lord, admittedly, my lord, they have not said that it should be followed in the letter also, my lord, but the spirit is required to be followed. But that spirit is also missing, my lord, in my case also, my lord. I have not seen any proper search memo, so cause, my lord. Only a so cause has been issued, my lord, and there is a distinction has been also carved out by the Honorable Apex Court, my lord, in as regards the so cause and a charge memo. Now, in my case only, my lord, I have found that only a so cause had been issued, my lord, asking for a me regarding the cause. That so cause I have also annexed, my lord, in my petition, my lord. My lordship may be pleased to find that so cause, my lord. My lord may be pleased to find at page 66, my lord, of my writ petition.
Yes.
My lord, this is a so cause on 16/9/2022 to Mr. So cause notice. Whereas it has been brought to the notice of the undersigned that you have been arrested by a team of Directorate of Vigilance and Anti-Corruption Assam in connection with accepting the bribe money amounting to rupees 10,000 from an individual, and you were arrested by the police via SAB case number so and so so and so. Whereas being one of the responsible official in the mission, you have violated the office decorum, office procedures, responsibilities, and commitments to the mission, and such type of work indicates your irresponsibility and gross negligence of your assigned duty. This kind of irresponsible behavior is totally unacceptable and against the work ethics. In view of the above, you are hereby asked to show cause as to why stern disciplinary action shall not be initiated against you for being involved in such type of works. Your reply must reach to the undersigned within 7 days from the date of receipt of this notice, failing which the disciplinary authorities shall be at liberty to pass an appropriate order ex parte. Now, my lord, regarding this, my lord may be pleased to find the order, this talk was issued on 16/9/2022, my lord. And my lord, I was behind the bar at that time. My lord, the order of my release on bail is on 21/9/2022. My lord, I have also annexed that is a part of my petition at page 68, my lord. I am not troubling my lordship with the few paragraphs, my lord. I am reading from page, my lord. My lord, I have been released on bail, and this is the bail order, my lord. Thereafter, my lord, I have made a reply on 23/09/2022 at page 71 of my writ petition, my lord. May I read, my lord, my reply?
Submitted your reply there.
Yes, my lord. I have submitted my reply, my lord, and thereafter, my lord, this from their affidavit, my lord, this is my representation on 27th of September 2022. Series of representations, my lord, which I have already brought my lordship notice, and the last hearing date, my lord, was on 6/10/2022, asking me to appear for hearing on 11/10/2022 only, my lord, at page 78. So therefore, my lord, the proper charge till date by framing the charges that what I have done. Yes, my lord, there is an allegation that I have asked for a bribe of rupees 10,000 from one of the teacher. But till date, my lord, that allegation has not yet neither been proved departmentally, because, my lord, the case which has been registered in the Special Judges Court, Honorable Special Judges Court, my lord, still pending at the evidence stage. Evidence has not yet been started. So neither, my lord, there is a judicial confirmation against my charge, nor they have departmentally confirmed by initiating a proper departmental proceeding. Under such circumstances, they are saying now, at this moment, my lord, after filing of the case, that as my contract has not been renewed, so therefore, deemed termination of my service is there, my lord. That is the stand in the affidavit, my lord. There is no principle of natural justice had been followed, my lord. And the spirit of the Assam service discipline,
If your contract is not renewed,
my lord.
where is the question of compliance of the service?
No, my lord. Now they have said, my lord, till, if my lord may be pleased to find that the order of stoppage of my salary, my lord, is of 2022. If which I have just brought into my lordship's kind notice, my lord, the order of stoppage of my salary of 16/9/2022 is at page 67, my lord. Now they have said that my contract was expired long back. Now, if a contract of an employee had already been expired long back, my lord, I was receiving salary till 16/9/2022, my lord. So therefore, the deemed, my lord, that the continuation they have, with their conscious decision, they have allowed to continue me in my service, my lord. So it is their fault, my lord, as
Order was passed.
my lord, because, my lord, what I,
So if they decided not to pay your salary,
my lord,
if your agreement,
my
contract agreement has already expired,
my lord,
then where is the question of compliance of natural justice?
no, my lord, the agreement is a,
Because you have not been discharged a person to the departmental.
no, my lord, now they are saying, after all these criminal cases, my lord, all these allegations of corruption, now they have come up with a plea, my lord, that my contractual agreement is now, they cannot, my lord, it is a case like that, my lord, that as you are claiming the service to continue, now where is your extension of the service, as you have committed certain wrongs, allegation, they have branded me, my lord, branded me as an, my lord, accused, as a person who has committed a gross violation of misconduct, my lord. That is the allegation against me. Had it been a, my lord, normal tenure, my lord, had it been a normal culmination of the contract, that termination would have come within the definition of a simpliciter termination, my lord. Then I do not have any case, my lord. But now here is a case, my lord, where my termination is stigmatic. There is a brand, there is an allegation against me, my lord. I may be wrong, my lord, subject to correction, but what I respectfully beg.
Where is that order, stigmatic order?
Stigmatic order, they have not passed till date, my lord.
Then how can you
No, my lord, my lord, the facts and circumstances, my lord, which is round counter my lord, the position of my service is like that, my lord. No, my lord.
Where it is?
No, my lord, may kindly appreciate.
The document.
Exactly, my lord. That document, that's why. That's
it also.
no, my lord, in the
that is that his service is not extended.
no, my lord, in their affidavit, my lord, what they have said, that they have taken a plea, my lord. They have taken a plea, my lord, that even assuming, my lord, may kindly appreciate their language, my lord, at page 121, which I have just brought into my lordship's notice, my lord. even assuming that his service contract agreement deemed to have been extended as he was allowed to draw his salary remuneration, even in that situation, such deemed extension of contract cannot be treated as still subsisting as the competent authority in SSA had taken a decision to stop his monthly salary from 16/9/2020 to white letter number dated so and so. Therefore, in view of the above explained facts and circumstances, it is the view of the SSA authority that once the contractual service of the petitioner ceases to exist, there is no requirement for the authority to take a decision as to what penalty is to be imposed against the petitioner pursuant to the proceeding initiated against him. My lord, admittedly, they have initiated a proceeding against me, my lord. Therefore, my contractual agreement was not, my lord, expired when the proceeding was subsisting. Now they have taken a plea, my lord, that as the, my lord, my contractual agreement was not renewed. Therefore, my lord, there is no requirement of issuing any order of punishment at this stage. Now, my lord, they have initiated the proceeding, my lord. Not only like me, my lord, many of the contractual employees under the SSA, my lord, after that tenure, their service has not been renewed by subsequent, my lord, this contractual agreement. They are still working there, my lord, in the department. I have those records also, my lord, because I could not, my lord.
But can you take the same plea in this?
Yes, my lord, because what the equality will come, my lord. The right to equality of Article 14 will come in my rescue, my lord.
Where is the document that they are working?
Yes, my lord, those documents they have supplied, my lord, but as I could not, my lord, file my rejoinder to this affidavit, my lord, this person is also in a very such a situation, my lord, that he has some imbalances with him, my lord. After this, he is around 50 plus, 52, 53 years now, my lord. So now at this stage, he has to go back from the service for an allegation, my lord, then obviously there will be trauma to this person, my lord. If my lord gives me a time, my lord, I can rejoin this, my lord, with all the sufficient materials that such persons, my lord, without, my lord, extending the contract, my lord, are still working, my lord, in the department. Only in my case, they have taken this plea, my lord, that there is no renewal of my, my lord, this agreement. So therefore, I cannot make this plea at this moment that whatever they like, they can do with me, my lord. That is not the, my lord, letter and spirit should follow with the, even for a contractual employee, my lord. Just a person being thrown out from the service for an allegation, my lord.
Lordship, this petitioner was demanding bribe from another fellow employee,
Exactly.
Lordship, for payment of his salary for 3 months, Lordship.
Allegation.
And this is his karma, Lordship. He got red-handed, and now he went to behind bar. Now, already we have issued prosecution sanction against him, and the criminal trial is going on. Lordship, exactly on similar situation, this honorable court upheld the termination of another employee under SSA, Lordship. Lordship, first I would like to place the judgment, Lordship, unless my friend would like to place his documents as regard other employees.
Yes, my lord. No, my lord, I have a very limited knowledge in comparison to my respected senior friend.
Exactly on similar situation.
My lord, my
in
senior
this case
friend has
also,
said, my lord, that I have been caught red-handed, my lord. That is absolutely an allegation, my lord. Until and unless an allegation is proved beyond a reasonable doubt, my lord, no, my lord, it is just an allegation, my lord. Now, tomorrow, an allegations can be made against me, my colleagues also, my lord. Those allegations are required to be proved beyond all reasonable doubt, my lord. That is the,
But there is no dispute about it.
my lord, my lord.
But sir, Nayak,
Lordship.
what happened to the disciplinary?
Lordship, one in
Whether you have
inquiry
taken it to logic
was what? Yes, Lordship. One inquiry was initiated, and he was asked to appear before the authority also after submission of the inquiry report. If Lordship comes to my
while preparing the inquiry, whether sergeant was part.
no, so far as SIR's memo is concerned, Lordship, that is a procedure under the Assam Disciplinary and Service Rule 1964. And so far as this present petitioner is concerned, Lordship, he is not a civil servant, Lordship. He is a contractual employee under SSA.
Okay, but the order is there, sir. Yeah, Dr. This court,
Yes.
that the spirit of disciplinary.
Spirit, yes,
disciplinary
that
appeal
spirit has been followed. That is why he
also-
was issued the notice. Notice was, that is only, for that reason only notice was issued. And if Lordship comes to page 109 of my affidavit, Lordship, second affidavit, Lordship may kindly see the recommendations of the inquiry officer also, Lordship. It was submitted on 19/10/2022, 109. 109, if Lordship comes to small a, b, c, etc. Lordship, the enquiry report was submitted on 19/10/2022 and placed before the disciplinary authority on 20/10/2022. The findings of enquiry are called out herein below. Lordship, these are the findings, Lordship. And ultimately, Lordship comes to page 114, Lordship. Page 114. After according prosecution sanction, in the meantime, Lordship, vigilance asked for prosecution sanction, that was granted. When the enquiry report was again placed before the disciplinary authority, the said authority, after having considered the report, directed the executive officer to call the petitioner in person and take personal hearing on the findings of the report of the enquiry officer. Accordingly, petitioner was asked to appear before the executive director in person on 24/3/2023 at 12 noon in the State Mission Office, SSA Assam at Kahilipara, Guwahati 19. But as per available materials on record, the petitioner did not appear before the executive director on the day of hearing, that is 24/3/2023. And if Lordship then comes to last paragraph, Lordship, of my affidavit, that is page 121. That bold portion my friend has already read out, Lord. So that is the other part, Lordship. So his
So,
contract was
in
still,
respect of disciplinary proceedings, you have not passed any order.
here it was decided as his contract has already expired. At this moment, no requirement of imposition of any penalty law. But the report was there. Report was there. He was called for personal hearing also. He did not appear. And ultimately, authority, when considered, Lordship, they found as he is no longer in service under SSA, Lordship, there is no use of passing any penalty order against the petitioner. That is the stand of the SSA, Lord. But exactly, Lordship, on similar situation, one order has been passed by our High Court, Lordship, by coordinate bench. This is WPC number 3949/2023, Lord.
Keep it with you.
Lordship.
In the meantime, let I
Yes,
reply
Lord.
to your appeal.
Lord. My Lord. Lord.
My lord, that inquiry report has also not been furnished to me, my lord. That is another difficulty, my lord. If my learned friend can furnish that report, my lord, it will be helpful for me.
We have not taken any, we have not passed any order imposing penalty, Lord. And that is why we have explained what the reason for not passing such an order. At this moment, Lordship, no relevancy of the inquiry report, Lord. Our basic stand is 2016, your contract expired. You continued till 2022 because we kept paying you salary. From the moment we stopped paying you salary, it should be understood that your service contract has already expired. That is our stand. And that was the stand before this honorable court in the judgment I am going to place before your lordship. That has been appealed.
Or, yeah, or, order for,
Respondent number one, my lord. No,
the Punya Garden product step. Petitioner will file, apply to the affidavit, file with the then it tries for granting allowed or
my lord, highly obliged.
September. Witness the hearing letter.
May I please, your lord? This petitioner behind the bar more than 3 years, 2 months. The two ground I have prepared the bail application, one is
record
to
as
long
safe.
objection they have filed with it. Earlier
So,
to
where is the Kaya?
Your Honor, he He's appearing in another court. And also, Your Honor, as per the instruction that I've received from the department, today a witness was examined, and Your Honor may kindly call for the
Another
call for
one,
the report
another
of the
more
deposition.
witness examined today itself, Lordship. Only 2 witnesses examined. Lordship
They
pays for
collect it and file it before the court.
Yes, Your Honor.
Then where is Mr. Kyle?
He's
He
appearing.
will not be allowed to argue the matter. We are granting adjournment on your prayer. That is a different. But he will not be allowed to argue the. You inform your counsel. Are you authorized by NCT?
No.
No. Then
one thing, Lordship. May I say, Lordship. She is a minor daughter, Lordship. Petitioner is a minor daughter. He is a widow, Lordship. Divorcee widow, but so for that another ground I have taken in this petition, his daughter is feeling some diseases since few days. Lordship. For look after, there is no member in the family. This is
have
an
you submitted a
medical document not available, Lordship. She is residing with her family members in the Manipur, Lordship. Birth certificate we have annexed. She is a minor, Lordship. Birth certificate.
what is the
More than 3 years, Lordship. She is behind the bar. There is no possibility to conclude the trial within a short period.
So that's all right. You produce the medical document. We will examine the matter. If you have taken the plea, unless you produce the
not
medical
a serious,
how
not a serious, not a serious disease. Normal diseases. Some diseases are is suffering, Lordship. This is as per their information. They have informed me. Family members informed me to place this.
family members inform you all right. Ask them to transmit the document concerned medical.
With any condition, Lordship, your Lordship, with any stranger condition.
Pardon?
With any condition, Lordship, is allowed the bail of the petition. More than 3 years. Not on merits, we are commercial quantity, Lordship. This is correct, Lordship. With any condition, more than 3 years, Lordship, is behind the bar trial.
Next that you produce the evidence of the witness. Heard, Mr.
ABT hook.
Learn it for the heard.
R. Hussain, Your Honor.
Learn it.
Maybe so, yes.
Yep. Then of the same
Yes, Your Honor.
learn it counsel for the applicant. Not actually learn it counsel referring behalf of trial. The apprise this court that in the meantime the learned trial court has already examined one and the said evidence of the witness is required to be placed for the court or trial. Then the price for granting sometime here is allowed the method on Thursday. Or in the meantime, you produce the medical.
We'll try, Lordship.